Adjournment request, if any, from item number 1 to 3, from item number 4 to 16.
May I please, Your Lordship? Lordship, which consent of the victim is in item number 4, Lordship.
Adjourn.
Lordship, as regard item number 12, my lord, 1, 2.
Well,
My lord. Not today, my lord, any date.
adjourn.
To place. Four.
Yes.
May I please, Lordship? I beg to mention, my lord, item number 14, my lord. In this regard, my lord, actually subsequent cause of action has arisen and we have preferred another writ petition, my lord. So this may be closed to my lord.
In view of the fact that subsequent cause of action, petitioner in relation to subsequent cause of action, the petitioner has already approached this court by way of filing a separate petition. He wants to withdraw this.
WBC number, my lord, 39672.
Another petition, he wants to withdraw this petition, dismissed as withdrawn. Item number 1-4.
One.
Lordship, in item 11, your lordship, we have filed an affidavit in reply yesterday. That may be called for your lordship.
Okay, call for.
Lordship.
I beg to mention item number 6, your lordship.
Yeah.
Lordship, may I adjourn the matter for appeal.
Adjourn.
May I please, Your Lordship? Item number 8. Obliged. May I please, Your Lordship? I beg to mention item number 16. The senior legal advocate on behalf of petitioner is admitted in the hospital for heart surgery operation.
Adjourn.
Yes, my Lordship. Can we matter be adjourned for about 4 weeks?
4 weeks.
May please, Your Lordship. Lordship, I beg to mention item number 10.
Adjourn.
Lordship, there is an interim that may be continued. There's an interim, Your Lordship, that may be continued.
Let us see if the interim is there. He extended till next.
Obliged.
Any other request?
Yes, 17.
May please, Your Lordship. For listing of 2 IS on Monday, Your Lordship.
Why was that?
It's regarding the IS has been filed for implementing PIL, is illegal lotteries. There is some order has been passed in IS, Your Lordship. That is why we are going to
Seeking same order.
yes, Lordship. That is why.
May I please, my lord? I beg to mention item number 17. Senior counsel is in out of session, my lord.
70?
17, my lord.
Yesterday, madam.
Yes, my lord.
Quite a long time.
My lord, her health is not well, my lord. She is not well, my lord. She rushed to hospital in the morning session.
Yes.
Daily list for hearing, item 1 and 2.
May it please, Your Lordship. Senior counsel, Mr. B. Dutta is on his way. Can the matter pass over for the time being?
I'm in another court, item number 1. That is a part-third matter. I am coming here because of this matter.
So he's on his way from another
Let
court.
it be or
In 1 minute, he will.
because if I get entered into that matter, Lordship, then it will, yeah, that is in court number 2 and
You answer into this matter or that matter.
I am here, but I was not expecting an adjournment from the other side.
Time being.
Time.
Like he's on his way. It will take 30 seconds.
30 seconds. We should wait for 30 seconds then.
Wait for particular.
In that case, after some time, Lordship, let me come from that court.
For the time being.
Yes.
Yes.
Item number 3.
I could not.
Yes.
Yes, yesterday there was some bereavement of my family members, so I could not prepare very thoroughly. Even and whatever I remember, I will just start the case, my lord. My lord, there are what I find in this case, uh, the there was a contract. Contract was not done because there was agreement was not signed. There was a tender which is floated by railway for VPH. That is page 79. Kindly see 79. See 79, my lord. This is 17 on top.
Instructions or tender.
Yes, this is your lordship will look into it. VPH, second line, 24-ton, 1 VPH, train number so and so, Kamrup Express Station, ex-Digbrugad to Howrah station and back on round trip basis.
EPH means?
This is van parcel, high density, they said van parcel,
When parcel.
van parcel, one bogie only. One bogie, my lord, kindly the station is Dibrugarh, Howrah and back. If your lordship kindly see the train number and station. And running frequency 5 days per week.
One rack daily
Yes,
and for 5 years.
5 days per week.
Special Dibrugarh to Howrah
Yes.
station and back on round trip basis for 5 years.
Yes, 5 years. And reserve price they have mentioned, my lord, 214,020, but quoted rate I quoted 260. So I emerge in the highest. There is no dispute on that. I emerge in the highest. Now, kindly see at page 109, immediately, my lord, once your lordship, it is my bid was the highest. Then, my lord, letter of acceptance. I made an offer. They have to accept. Your lordship will find at page 109. This will be of important. Your lordship will kindly mark this letter 8/10/2021. Now, lordship will find the subject.
Just
Yes.
Yes.
Now, why I'm saying this letter is relevant? Because there is an observation made by the learned single judge. When the letter of acceptance has been issued, it should be counted as a letter of commencement. Once it is letter of acceptance is given, it is a letter of commencement, meaning thereby you have to start the operation. That's the view of it. That's why I say this is important, this letter. I'll show that minor. So now, if your lordship looks into it, next page at 110, 3, clause 3, security deposit. You are requested to submit security deposit in the form of mention in clause 7 of part 3 of tender document amounting to so and so within 15 days from the date of issue of letter of acceptance. As per the calculation below, security deposit should be valid for a period of 5 years.
Letter of acceptance by this railways.
Yes, correct. So you have to, my lord,
In response to your bid.
yes, in my response to my bid. If you see at page 111, next page, one is security deposit within 15 days. My lord, kindly turn to 1114. Agreement, you are required to execute the license agreement on non-judicial stamp paper within 15 days period from the date of issue of the letter of acceptance. All expenses so and so shall be borne by yourself. So this is the situation. Now, my lord, we could not deposit within 15 days. Lordship will kindly note it. We have failed to deposit the secure deposit within the stipulated period which they have mentioned. Now, kindly see next letter 112. Lordship will kindly note down we have failed to deposit within that 15 days period which they have mentioned.
Yes.
My lord, kindly see at page 112.
There was a time limit for deposit of
511 to
for the security deposit, but there is no time limit for
There is a time
15
limit.
days,
15 days
agreement
time
is
limit
also
is there.
15 days. Fine.
15 days. Which subsequently I will show, my lord, they have condoned this. The railway has condoned. 511, my lord, kindly see at page 112.
Yes.
This is a letter where we submitted a secure deposit. Lordship 5. We are willing to commence the operation so and so. We are submitting demand draft so and so. 5th November so and so amounting of rupees 40 lakh. We request to kindly provide a draft copy of the agreement. Yeah, my lord will kindly note down there is a delay of 12 days. 15 within 15 days, but delay of 12 days.
After expiry of 15 days.
15 days. Now, this letter, I feel that it's an important letter at page 114.
Yes.
Before I read this letter, I like to tell your lordship one thing. Letter of acceptance and the allotment order, these are two different things. Once I given an offer, they accept. So that is a letter of acceptance. And the allotment order is the work order they issue. Now, if your lordship kindly see now.
Letter of acceptance and work order.
Yes, that's an allotment order. Your lordship will kindly use the word allotment order. Now, if your lordship looks into 114, page 114, this is their letter which has been written to us. I just read this letter. Undersigned is pleased to inform you that a competent authority has accorded his kind approval to your delayed submission of the security deposit money as well as commencement of loading of the lease VPH by certain train, by the subject train. You are therefore requested to immediately furnish your intermediate loading, unloading point so that the allotment order may be issued according to ensure commencement of lease operation at the earliest. So, my lord, when the letter of acceptance was issued, security money was deposited, they accepted, it was condoned. Now they said that please let us know your intermediate loading and unloading points, because that you have to go throughout, which are the points. And thereafter we'll issue for the allotment order, we'll issue for commencement of lease operation. Now, lordship will look into. So immediately at page 115, kindly look at 115. On 27/11/2021, we have informed them, our intermediate station. Kindly see, my lord. This one, intermediate station, this one. This is not intermediate station. Not intermediate. Number 26/11/2021, then 27, prayer for allowing platform loading. Lordship got it, my lord. Now, lordship will kindly turn to page 118. This is the allotment order. The actual issue starts from here. Allotment order. Kindly see the allotment order. The lordship will kindly mark it 29/11/2021. This is important, my lord. 29/11/2021. Now, my lord, first particular paragraph is important. I just read, with your lordship permission, 118.
Yes.
In reference to this office LOA, that is letter of acceptance reference, as you have deposited the requisite SD, PG money amounting 40 lakhs so and so, DD number so and so, drawn in favor of so and so, and as a delayed remittance of SD PG money has been condoned by the competent authority, you are requested to start loading of the leased out 24 tons so and so, come by, lordship will kindly use the by 7/12/2021 on receipt of this allotment order as per your commitment made in your application submitted dated 8/11/2021. Your lordship will kindly mark that 8/11/2021. Your lordship will kindly note it is page 239. Kindly note that 239. That letter which they say as per your commitment made in your application. We made some application.
You made some application. Now, first of all, clarify what is this application?
I will clarify. 239.
Just a minute. What is this application? Annexure 7.
239.
No, Annexure 7/115.
Annexure
7.
Wow. This is loading prayer for allowing platform loading of perishable consignment.
So it was not in the contract. Perishable, this consignment
Yes.
was not in the contract
Yes.
and you saw.
Yeah, I saw.
He may be allowed to.
Yes, correct.
That permission was not granted.
That is of course not granted, but I just brought notice to the court what are the letters I have submitted before them. Now, my lord will kindly see page 118 is the allotment order, which your lordship I have read there. And they said that this allotment order, that you start operating. The allotment order issued by 7/12/2021, you start operating because you made a commitment on 8/11/2021. Now that letter is at page 239. What is the commitment we made? 239, kindly look into that letter. 239, my lord. Lordship got it, 239? My lord, we so and so long-term lease on various so and so. Our operation cover large railway network. Recently, we were awarded LOA so and so back on round basis trip for a period of 5 years. It is to be noted, LOA was provided in the midst of Durga Puja, which is a major festival in northern and eastern part of India. Festival is followed by so and so, making the month of October, November a festive season during this period.
So this letter you have written on 8/11 to
8/11.
So that is.
Why?
After that, sir,
When my lord,
that is just a minute, sir.
yes,
Let me clarify.
before the allotment order was passed. This is previous letter, 8/11.
29, okay, previous.
These are previous, my lord. Why, my lord? I'll tell you, your lordship, why it's getting confused. Because the letter of acceptance issued, I paid the secure deposit on 5/11. Now they inform us that your secure deposit which you have given us, we have condoned. Now, once they accepted, we have written back to them on 8/11/2021. And look here, we are ready. We are ready with this. So unless you don't give an allotment order, we can't start. Now your lordship will kindly see. I'll not trouble with that entire. Kindly see the last paragraph.
Yes.
Considering the extraordinary situation mentioned above, as per amendment number 3 of comprehensive parcel leasing policy, white letter dated, it is requested kindly grant the permission to start the operation of said by train number so and so, railway back on round trip basis from 22/11/2021. Lordship got it, my lord? Pursuant the stamp paper. Now lordship will kindly mark this sentence. The stamp paper for execute agreement has already been submitted by us on 5/11/2021. Please arrange the same as early as possible for marketing purpose and issue work order also. So till then, my lord, when the deposit money, we have stamp paper we have taken, we said, because there has to be signing of that contract. So we have given to them. They have to intimate to us. Please come forward and sign the agreement. Which they have not done till the allotment order was issued by them. Later on, my lord, I will show my lordship when they have called us.
Yes.
Now, my lord, will kindly see on 29/11, we go back to 118 again. We go back to 118. Your lordship has read the letter of 8/11/2021. So on 29/11/2021, the allotment order has been issued by them. Now, if you see at page, next page, at page 80, this is 119. Kindly see last paragraph, last line, 3 lines. As per your commitment by letter, you are requested to start loading of the lease VA without any further delay. You will have to execute a contract agreement in this regard. At last 3 lines, my lord. As per your commitment, so and so, you are requested to start loading lease BPH without any further delay. You will have to execute a contract agreement in this regard. So the contract agreement has not been signed. Now, my lord will kindly look into it. 124, my lord. Now this is in the 124. This is on 17/12/2021. Kindly look into page 124. My lord, this is the railway has written letter to us. Kindly say subject. Lordship, what is execution of the contract? Your letter, so and so reference, please to inform me the contract agreement for so and so. So and so is ready in all respect and waiting for signing. You are therefore requested, please attend this office on 20/12/2021 with your office seal for signing the same. So they called us, they said, your contract agreement is ready. Now, please turn to page 125. My lord, we could not go to their office. Next letter, my lord, 21/12/2021, they have written. Please recall this office letter where it is informed to attend this office on 2012 for signing the contract agreement for the lease so and so, which has been awarded in your favor, being the successful bidder. However, as you have not attended the office till date, it is further requested for attending so and so for signing the same and comments loading for the lease BPH accordingly. So you've got it, my lord. Now, my lord, next page, some power of attorney has to be executed from our end. So at page 21/26, who will go and who will sign, all this has been given. At page 120, this. Now at 130, this letter is important. 130 is 24/12/2021. Kindly see the subject. Subject is commencement of loading and signing of CA. So and so. My lord, this is what 1, 2. I'll not. I'm 4. Kindly see 4 now. The competent authority at headquarters has accorded sanction on 26/11/2021. The lordship will kindly mark this date, 26/11/2021, for relaxation of 30 days period of commencement of loading, which was also for with limit intimated to you by this office letter dated number 26/11/2021 with the advice to furnish your option for intermediate loading unloading station. Also got it? 26/11/2021. This date is important. Now next, on receipt of your option for intermediate loading unloading points on 27. Now your lordship has asked that whether it was rejected or not, because we have to inform them about the intermediate station. Now, on receipt of your option for intermediate loading unloading point on 27/11/2021, allotment order has been issued. On the next working day, that is on 29/11/2021, with the request to start loading without further delay. So my lord, 26/11/2021, relaxation for 30 days by the authority, because I'll read that letter. And thereafter, they have asked my point, intermediate loading and unloading points. On 27/11/2021, I have given at 5. And thereafter, they said an allotment on 29/11/2021, we have given allotment order of 5. I am clear, my lord, on this point. Now, kindly see now at page 131, next page. Under the above circumstances, it is intimated overall relaxation period for commencement of loading is expiring on 25/12/2021. Therefore, you are requested to commence loading of the lease BPH on or before 25/12/2021. Why they said, I'll show the allotment. My lord, the orders, that is your lordship will kindly find at page 118. Kindly see 118, my lord. Why they said it is going to expire on 25/12.
Yes.
118, 1 second. 118. Kindly see this date of allotment, 29/11/2021. Or 26/11. No, I'm sorry, 114. I'm extremely sorry, 114. 114, I'm extremely sorry, 114.
Yes.
This is 26/11/2021. So they counted from 26/11/2021. Allotment, when an allotment is given, there is a policy, leasing person, I'll show it, that within a period of 15 days, when an allotment order has been issued, you have to start operating. And maximum another 15 days time you'll get the relaxation. Total is 30 days. Now, what they said that 26/11/2021, our higher authority has taken a decision to give you the relax 26/11/2021. If that be the case, from 26/11/2021, the maximum 30 days period will expire on 25/12/2021. So that's the period they have calculated. Now I'll come there. That's why I'm just making clear what is there, what they wanted to say. This is what they are saying. Now, if your lordship looks into it, now the rule to take us. See 179 the rule. 177 is the rule. Kindly see 177. Kindly see at 177. Lordship got it?
Yes.
See 20.1. My lord, am I clear so far a letter of acceptance, letter of allotment is concerned? So letter of acceptance has nothing to do with the letter of allotment. Now this allotment order once, now kindly see 20.1.
Yes.
On allotment of contract, which is on 29/11/2021. The successful bidder shall be required to commence the loading within a period of 15 days. Failing with the contract will be terminated and earnest money security deposit will be forfeited. Now kindly see, accepting authority shall be empowered to condone the delay on the merit of the case on written application from leaseholder and give another 15 days maximum period leaseholder for commencement of the contract. Now what they are calculating from 26/11/2021. They can, now my humble submission before your lordship is that is not in accordance with the allotment or the rule comprehensive policy where it starts from the date of allotment of the order. So if the date of allotment of order is 29/11/2021, they have to count from 29/11/2021, 15 days, then thereafter coordination of 15 days. That's my humble submission before your lordship. Their calculation, they said, my lord, security deposit, we have condoned. Also, the commencement of the loading also we have condoned. That cannot be, my lord. Security deposit one hand, allotment of the work is, allotment order is allotment of contract. So this allotment of contract is on 29/11/2021.
So as per you, it expires on 28.
28.
28.
Correct. 28. That's my lord. So we went. So 27, they said in their affidavit, they said, my lord, we went on 27th. 27th we went in their office. They said, no, we can't entertain. Now because that period is over. 25/11/12/2021 is over. Now, my lord, they refused. Thereafter, my lord, there was an impugn order which was issued by them somewhere at so 3/1/2022 at page 137 on 3 counts. They have passed this impugn order. I'll just tell you a lot. Then I'll read. One is they said page 137. 137. 137. Yes.
Yes.
Now, my lord, there are 3 things here. My lord, we just hear these 3 things, my lord, what they have done it. One is they have terminated my contract and the amount has been forfeited, the security money. Second, my lord, without any notice, they have debarred for a period of 2 years. 3, my lord.
That period is already over now.
I'm sorry, my.
That period is already over.
That is over. Now, my lord, now let it, 2, my lord, 2 issues. that issue, my lord, maybe that period is over, but that always remain under that issue, because all the time, there is a contract, a new contract, there is a column which I have to, my lord, have to insert whether there is any debarment has been issued or not. So what I am praying on that side, that part, my lord, three part. One part is debarment. My lord, that they will issue a notice to me, I'll give a reply, which they have not done. Even blacklisting, your lordship, a notice has to be must. Is there? Even that period may be over. Number two, my lord, only what your lordship will decide now about forfeiture. That forfeiting, that because I have been told that a tender has been floated. And they said that has been kept in abeyance because without a leave of the court, they have not gone ahead. Tender has been floated.
But prior to that, the court has, on your asking, the court has allowed you to undertake the work, which you ultimately after 2 months, you said, okay, I can't.
Yes.
That is there.
No, that is there, my lord.
That is there.
Only 1 day they have, only 1 day.
No, the problem is that,
In June
my lord,
2022,
nobody, no party. I asked my client, say why? Because no party is willing to enter any contract because they have to enter a contract with a party. Unless there is no signing of a contract, because signing of a contract was not there.
But you yourself has said before this court that I am ready to undertake the work now.
No, that's true, my lord. Now the position.
24th of June, if I remember precisely.
No, yes, your lordship is right. Your lordship is correct, absolutely correct.
On 20
That is under your lordship, that's a correct.
You have given undertaking before the court.
No, that is, that's,
Since we have already, which column, I mean, then the appellant has found to be highest, since the appellant now willing to undertake the.
no, that's true, my lord. That's your lordship.
This
No, that's your lordship is absolutely correct, my lord. Only what I'm saying, maybe a third party right has been created, what I felt, my lord. Third party right may be created because they have gone ahead.
This
with
is
this-
one of the facts.
Yes, the third party, I don't know, my lord. Again, there has to be some added party, I don't know. Maybe there is an order passed by the court, that order will always stand. But your lordship has asked them to go ahead.
And then on 24/8/2022, Mr. Didas, the appellant, is still the appellant could not undertake the work.
Yes.
This is
Yes.
2.5 months or something.
Yes, correct. Right. Your lordship is absolutely right. Correct. Only the point remain here is, my lord, that what I pray before your lordship to short the entire that without any notice,
30 days period starts from 29/11/2020.
absolutely, that's what my case.
Not on 25.
No. That's my only case, my lord. Second is that what I pray at this stage, my lord, point A, that debarment has been done, it will always remain. What I submit before lordship, they can give a notice to me, I'll give a reply to it. This is A, point A. Point B is that they have forfeited the security deposit. Now whether a forfeiture of the security deposit, if it is a case where they can make out that 26/11 I failed, because period will not be counted from 29/11, it will be only counted from 26, then of course your lordship has to take a decision on that point. I think that's-
Single judge is dealt with.
Now the learned single judge. I will show it, my lord, learned single judge. I could not go and I told my lord yesterday what I remember I have argued. Learned single
Let us
judge.
see together, sir.
Yes, of course, my lord. My lord, can I just take your lordship to affidavit which has been filed by them? Then I go to the judgment of the learned single judge. 220 kindly see, my lord, 220. If your lordship kindly see 220, the affidavit of the railway, no, see, kindly see para 7, my lord. Para 7, lordship got it? 220.
Yes.
That regard to the statement made in para 8 of writ petition, the answering respondent state, petitioner was to remit the requisite SDM within 15 days time from the issuance of the LOA. In this case, the SDM was to submit latest by 22/10/2021. As the petitioner submitted the same with a delay of 13 days, the matter was put up to tender accepting authority, which is competent to condone delay in commencement of loading. As because the accepting authority was on leave, and when he resumed office, the period with divisional power for condoning delay got expired. The matter was put up to the Principal Chief Commercial Manager, Railway on 22/11/2021 for granting relaxation in light of liberalized policy guideline circulated by FM Circular number 22 of 2021, being the competent authority to grant the extension of 30 days time period for commencement of loading. The competent authority has granted the maximum relaxation period on 26/11/2021. On receipt of the file on 26/11/21 in the evening, the petitioner has intimated accordingly, my lord, the kindly word, intimated accordingly, and on the next working date, that is 29/11/2021, the allotment order was issued to the petitioner, asking the petitioner to start the loading by 7/12/2021 as per his commitment by so and so. Now, if your lordship, now once again, I will just trouble 223 page. One page, paragraph 10, my lord. No, my lord, kindly see that in receipt of the statement made in para 11, the answer respondent stated is a fact that one repenting of the petitioner attended the office of Senior Divisional Commercial Manager on 27/12/2021, identifying him to be a Neeraj Kumar Sinha for execution of contract agreement on behalf of the petitioner on the strength of power of attorney given by the petitioner. But signing of the CA could not be entertained since the maximum relaxation period for commencement of loading has already expired on 25/12/2021. Now we went within that period, which is going to expire on 29. They said that we can't entertain because we have calculated from 26/11. That's the case, my lord. And 2024 to page 224, they have given how they have calculated. Kindly turn to next page, 224. Letter of acceptance issued on 8/10. Money has to be deposited in 15 days. 22/10. Had the SD money submitted latest by 22/10, allotment order could have been issued on 22/10/2021. After issuance of allotment as per tender condition, petitioner required to commence loading of so and so within 15 days. 15 days expire on 5/11/2021. As per tender condition, extent of continuation period commencement of loading empowered by tender authority is up to 15 days from 6/12/2021. It should be 6/11, I think. 6/11. There is something. 6/11. The 15 days continuation period by tender accepting authority would have been up to 20/11/2021. 30 days continuation period for commencement of loading empowered by principal commercial manager would have started from 21/11/2020. However, it was counted from the date of granting, that is 26/11/2021, and that way 30 days election period completes on 25/10/2021. This is their calculation, my lord. Now let us go through the judgment, my lord. Your lordship just want to just see that again. Yes. 224. These are, my lord, they calculated on the basis of hypothetical. They say if you have deposited on time, that this would be the date.
Yes.
No, one just trouble your lordship again with 220, the affidavit. Kindly see the last line of 220 page, para 7 or last. On receipt, lordship got it? 220 of the railways affidavit.
Yeah.
7, last line, on receipt of file on 26/11/2021 in the evening. Petitioner was intervened accordingly and on the next working day, that is 29/11/2021. Lordship got it? Now it's kindly see at page 269. This is the calendar of that 269. Next working day, kindly see next working day. Lordship got it? See the December, my lord. Sorry, November. November, kindly see 26 was the Friday. Lordship got 26 November, 27, 28, Saturday, Sunday, and the next working day is 29. So they have given 29 on next working. But when you, yes, my lord.
114 page.
I'm sorry,
Page 114.
114. 114. I'll tell you. 114. 26/11, 2021.
They have intimated you, though the work order was, this allotment order was issued on 29/11,
Yes.
but on 26/11/2021, they have intimated you.
No, maybe intimated.
Undersigned is pleased to inform you.
No, my
the
lord.
Competent authority has kind of approved
No.
delayed submission of security as well as the
Secure-
commencement of the loading of.
No, delayed of security as well commencement. So this that's why I said these two letters has to be taken into two different aspects. One is a security deposit and one is allotment order. Now allotment order, you get a maximum 30 days from the date when the allotment is being issued. If it is 29/11/2021, maximum you'll get 1 month. What they have done, my lord, they calculate 26/11/2021. So maximum is it get expired on 25/12/2021. Now why I want to show it. If the reason is that working day, the next working days will be 29. 25th also was a Christmas day. Kindly see, I have written to them at page. Kindly see at 133, my lord, all letter. See 133. Kindly see 133, my lord. See, my lord, 133, my lord. Immediately on 25/12/2021, kindly see the letter and see. Most we accept the contention so and so, kindly appraise the author so we'll be able to attend the office of the execution agreement on so and thereafter we shall commence loading. Now kindly see Christmas and revenue. Now, if you see at page 269, December 25th was is a Saturday. It was a holiday, Christmas day. Sunday is 26th. 27 is a Monday. We went on 27th. So your lordship will kindly appreciate as per clause 10 of the General Clauses Act that we get that benefit. We get the benefit.
Christmas was on
25th.
the Hollywood was on 24th, sir.
25th is Saturday.
24th in the bottom,
They have asked to come on 25th.
in the bottom in this calendar 269.
Yes.
These
25th is Saturday.
Monday, 2nd, Assam Divas,
Yes.
or so, or
This
Divas
was
so,
almost
so,
a name.
24th Christmas Eve. 25th was not the holiday.
That's what I've been told, my lord, subject
So
to
this is
correction.
the calendar which you.
Yes, I have seen that calendar, my lord. I have seen that. No, I holiday, no, you be confirmed. Why you are saying? Confirm corona. It's not. You just see, check. Railway नहीं Railway. Railway नहीं.
Yes, now.
We got the office of Eastern Railway where they said that Christmas, that is 25th, is a holiday. We got a chart of the, but that's my lord, that's a point where there's a most relevant point is from the date of allotment. That's the only point. And that is page 191, kindly see, my lord, that is the comprehensive parcel leasing policy at page 191. 20.1.
That
Right.
you have already mentioned,
Yes, 20.1. That your lordship will kindly note it, my lord.
that you have already mentioned at page 177. is-
Yes, right. That's the case, my lord.
Now, how the thing is that
Yes. 352. Kindly see 352 first. Lordship will look into 352. Paragraph 10, my lord. In the middle.
just, so better to read from para number 21 of the judgment.
Yes. Para 21, 365. Twenty-one.
eh, From para 21.
21. I have heard the page 365.
Yes.
I have heard the learned counsel party and have also perused the material record. Record revealed that on 25/8/2021, notice inviting tender was issued for leasing out 24 tons of so and so. Various documents form a part of the tender document. Third part is the instruction to tenderer. In the said instruction tenderer, various terms and conditions have been mentioned therein. Issue involved in the instant proceeding relates to the interpretation of clause 8A and 8B of the said instruction to tenderer. These said clause have already been quoted here in above. It al-
That's 8(1) and 8(B).
Yes, let's see that now. Page. Turn to page, my lord,
That is
80.
I think the learned single judge has.
Page, yes, 80, kindly say 80. Page 80.
In this judgment also they have put the learned
Yes.
single judge has put at
Yes,
failure of lease order to start or operate lease contract.
yes. Page 80 kindly be looked into. Page 80. Or your lordship is referring to what, which page, my lord?
This
348,
internal page 5 of the judge. Improved judgment.
340, I'm sorry, I'm saying. 348.
348.
Yes. Failure on leaseholder to start or operate lease contract. On allotment of contract, the bidder leaseholder shall be required to commence the loading within a period of 15 days, failing which the contract will be terminated, unless the deposit will be forfeited. Accepting authority shall be empowered to counter and delay on the merit of the case or written application from leaseholder and give another 15 days to the leaseholder for commencing the contract. If the highest bidder fails to take up to start the lease contract, they may be debarred for at least 2 years from the participation in the tender in the division Journal Railway. A reading of the above quoted two subclause would show that upon the, yes,
For the sake of.
yes, 365 now,
In para 21.
21. Now we read that minor third part, so and so 8AB of the instruction. Said clauses have already been quoted here in above. It has also mentioned here in the above said clause 8M are similar in content with clause 20.1 and 20.2 of the comprehensive parcel leasing policy. It is also relevant here, it is mentioned amendment was made pursuant of floating of the said tender on 4/10/2021 known as amendment number 13. In terms with the said amendment number 13, Clause 20.1 of the comprehensive parcel leasing policy was amended. Principal Chief Commercial Manager, upon recommendation of division, was empowered to grant relaxation the period of commencement of the contract up to a maximum period of 30 days after duly consider the merit of the case. It is also relevant herein to note said power entrusted upon the Principal Chief Commercial Manager of the Zonal Railway could be exercised when circumstances arises beyond the control of the successful bidder, curfew, lockdown, so and so, to prefer an appeal within 15 days of normalization of the situation. Said power therefore cannot be exercised at the whims of the authorities, but has to be ground where the circumstance exists beyond the control of the successful bidder. The facts of the instant case would further show petition of a submit tender on 21/9/2021 at 12:41 p.m. Thereafter, on 8/10/2021, letter of acceptance was issued containing the various terms and conditions. Clause 3 of the letter of acceptance stipulates the secure deposit of so and so was to be deposited in terms of clause 7 of the instrument tender within 15 days from date of issue of the letter of acceptance. Clause 4 of the said letter of acceptance stipulates that the petitioner firm was required to execute the leasing agreement on non-judicial stamp paper of ₹100 within 15 days from the date of issue of letter of acceptance. Clause 5 of the letter of acceptance categorically mentioned all the terms and conditions of the tender document shall be applicable, meaning thereby clause 8A and clause B of the instruction tender was applicable with effect from the issuance of letter of acceptance. It further reveals from the record by communication dated so and so, petitioner firm had duly accepted the letter of acceptance. Consequently, a binding contract ensured upon the petitioner for compliance with the tender condition which included clause 8 and B. A perusal of clause 8A stipulate the commencement loading has to be done within 15 days from date of allotment of the contract. As already stated herein above, with the issuance of letter of acceptance on 8/10/2021, it would be deemed that a contract in question has been allotted in respect of the matter was also accepted a petitioner firm by accepting the said letter of acceptance by the communication as mentioned above. That's what I have said. The letter of acceptance.
But if we.
I'll read. No, just one. This is what I said. Told your lordship, that's the first point. We said letter of acceptance has to be counted, has to be deemed as a letter of allotment that you have to commence. By normal, my lord, in a civil court, like a letter of UX offer, acceptance has been given, you start doing. That's what the normal. But here, my lord, situation because there is terms and condition. That's what I am saying. The allotment is something else and the secure deposit is something else. Now, next 22. Now, in terms with clause 8A, petitioner firm was required to commence the loading within a period of 15 days, which would expire on 22/10/2021. But the petitioner firm did neither submitted the secure deposit as was required in terms with clause 7 of the instrument tender as well letter of acceptance dated 8/10/2021, nor commence the loading as required under clause 80 of the instruction to tenderer. A day before the expiry of the period of 15 days, petitioner firm issued a communication dated 21/10/2021, wherein the petitioner firm intimated an account of certain difficulties faced. Petitioner firm was not in a position to submit the bank guarantee and the execution of the agreement commencement of loading for the subject contract. The petitioner firm, by the said communication, requested for granting an additional period of 10 days to execute the leasing contract on submission of the requisite amount of BG. It was further requested to grant the petitioner firm 10 to 15 days so the petitioner firm may start leasing work smoothly. Immediately on receipt of the said communication dated 21/10/2021, response number 6 by the communication dated 22/10/2021, inform interrelated petitioner firm that a secure deposit has to be remitted by the successful bidder within 15 days from date of issue of letter of acceptance. It was mentioned that in terms with para 20.1 of the commercial parcel leasing policy, it was requirement that no allotment of the contract, the successful bidder leaseholder shall be required to commence the loading within a period of 15 days, failing which the contract will be terminated and the earnest security deposit will be forfeited. In the said communication, it was also mentioned, it is the accepting authority who is empowered to condone the delay on merit of the case on written application for a leaseholder and can run another 15 days maximum period leaseholder for commencement of the contract. On the basis thereof, the response number 6 therefore requests a petitioner firm commence loading of so and so by way of submitting requisite SD money in the form of bank guarantee, FD or so and so. Petitioner thereupon 5/11/2021 submitted demand draft of a value of 40 lakh with a secure deposit amount. Petitioner firm also on 5/11/2021 submitted a stamp paper for execution of agreement. While doing so, while the forwarding letter dated 5/11/2021, petitioner firm was also requested for providing the draft copy of the agreement and the work order. By the time the petitioner firm submitted said demand draft, initial period of 15 days has already expired, and the subsequent period which could have been condoned by the accepting authority was about to expire. Inasmuch deposit of the secure deposit was submitted 13 days after expiry of the initial period of 15 days. The record shows at the relevant point of time, tendering accepting authority who was competent to condone the delay was on leave for which the divisional office, the tender accepting authority did not have the power to condone the delay beyond the expiry of 15 days after the expiry of the initial period of 15 days. It is in these circumstances that the petitioner firm issued the communication dated 8/11/2021, whereby petitioner firm invoked amendment number 13 of comprehensive parcel leasing policy and thereby requested permission to start the operation of the said BPH by train number so and so and back on round trip basis from 22/11/2021. It was categorically mentioned in the communication dated 8/11/2021 the petitioner would be ready to start operation from 22/11/2020 in full swing. Record further goes to show, in view of the accepting authority being on leave, at that relevant point, the matter was placed before the principal chief commercial manager, headquarters on 22/11/2021 for granting relaxation in the light of liberalization guidelines circulated by FM circular dated 4/10/2021. Competent authority granted the maximum relaxation to the petitioner firm on 26/11/2021, and immediately on the said date, petitioner was duly informed delay in submission have been duly condoned. The petitioner firm was directed to commence on loading. The petitioner firm immediately on receipt of the said communication dated 26/11/2021 issued a communication dated 27/11/2021 raising certain issue pertaining to allowing the petitioner load perishable consignment. At this stage, it may be relevant herein to mention 26/11/2021 was Friday, and on Monday on 29/11/2021. Response number 6 issued the allotment order whereby the petitioner asked to start loading on 7/12/2021 on receipt of the allotment order. It was mentioned petitioner was requested to deposit 50% lump sum freight to each and along with 2% development charge of so and so as available by so and so. It was also mentioned as per a commitment made by the petitioner firm so and so 8/11. Petitioner firm request start loading on lease VPH without further delay, and the petitioner was also informed to execute a contract agreement in this regard. At this stage, it may be relevant here to mention concept of issuance of allotment order for commencement loading is nowhere to be found in terms with the instruction of bidder or even in the draft agreement, which forms a part of tender document as well commercial leasing policy. A perusal of the said document only show loading has to be commenced upon allotment of the contract. The petitioner firm, instead of commencing the loading operation, for the first time raised the issue that without the execution of contract agreement, it would not be possible for the petitioner firm to operate the lease PPH as a loader and parcel aggregator were not allowed to offer or load consignment on the lease BPH without the adjudication of the agreement. While this said communication, it was also mentioned, petitioner firm would also request some time for reaching to the local traders and parcel aggregators for the successful intermediate handling, and under such circumstances requested 2 to 3 weeks time for starting operation of lease VPH. In the meantime, a suitable date may be fixed for executing the contract agreement for operating of the lease VPH by the petitioner firm. At this stage, it will be relevant herein to mention neither in the instruction to tender nor in any part of tender document there is any mention commencement of loading shall start with the execution of the contract agreement. Upon receipt of said communication dated 6/12/2021, the response number 6 immediately replied on 7/12, asking the petitioner commence loading of lease VPH with effect from 14/12 positively. It was also mentioned that as far as the matter of agreement was concerned, the same was under process and it would be executed shortly. At this stage, it is very pertinent to mention contract in question is a revenue earning contract for the railway, and with each day of delay in commencement of loading, railway authority have been suffering revenue loss. It is relevant to mention, taking into account the reserve price as was mentioned in the instruction to tenderers, which was as far as less than the bid submitted to petitioner firm. Loss which the railway would suffer for non-commensurate loading for each day was 214,020 was, and weekly loss of 1070,100. Monthly loss is 42,800, 42,80,400. It is under such circumstances have been insisting the petitioner firm to commence loading. Petitioner firm, instead of commencing the loading operation, issued another communication on 14/12/2021, wherein requested the response authority to execute the agreement, and thereupon the petitioner shall be able to operate the lease within a week thereof. In right earnest, the response authority thereafter asked the petitioner firm in a communication dated 17/12/2021 to appear before Office of Response number 6 on 20/12/2021 for signing of the contract agreement. Petitioner, however, in spite of receipt of the same communication, did not appear on 20/12/2021 for signing of the said contract agreement. The response number 6 thereupon, on 21/12/2021, again requested a petitioner firm to appear before the response number 6 on 22/12/2021 for signing of the agreement. Petitioner firm again did not respond to the same in spite of receipt of said communication. Even there is no explanation writ petition as to why the partners of petitioner firm or any authorized could not be present on 20/12/2021 or 22/12/2021 for signing of the contract agreement. Situated thus, on 24/12/2021, it was intimated to a petitioner firm period of 30 days with the maximum election period would be expiring on 25/12/2021. And as such, the petitioner firm should commence loading on or before 25/12/2021. A perusal of the communication dated 24/12/2021 would clearly show that there was no request or direction to petitioner firm for purpose of signing the contract agreement. However, the petitioner firm did not take any step for loading. On the other hand, issued a communication on 25/12/2021 intimating to the response number 6 that authorized person will be present on 27/12/2021 to sign the contract agreement and thereafter shall commence loading. As the maximum election period has expired on 25/12/2021, response authority did not enter into contract agreement on 27/12/2021, when the authorized representative petitioner appeared and terminated the contract on 3/1/2022, along with forfeiture of secure deposit, debarring the petitioner firm from parties in similar contract for a period of 2 years in respect of safe division. Above facts would clearly go to show authority have granted the petitioner ample opportunity to commence the loading. Clause 8A categorically mandates commencement of loading from date of allotment of the contract, and issuance of letter of acceptance already stated herein above would be deemed to be the allotment of contract. More so, when the said letter of acceptance was duly accepted without any question. Under such circumstances, non-commencement loading violates the mandate of 8A to the instruct render, and consequently railway authority was justified in terminating the said contract, forfeiting the security deposit due about the submission tender. The non-compliance of the clause 8A would result in befalling the consequences under clause 8A and B. And under such circumstances, the court does not find any illegality in passing the impugn order. Said aspect of the matter can further be seen from another angle. The instant contract in question is revenue earning contract of railways, and with each day of non-commensurate loading, there is revenue loss to railway authority, or in other words, loss to public exchequer. In terms of tender document, from required to start loading latest by 22/10/2021. Non-commencement of the loading operation has called colossal revenue loss to the railway authority, for which the railway authority were justified in forfeiting secure deposit. Coming to the submission made by learned counsel petitioner about the application of clauses 10 of General Clauses Act, the judgment of Supreme Court in so and so. This court is of the opinion that the said are totally misplaced in the facts of the instant case. In the petitioner were requested to attend on 20/12/2021 and 22/12 for signing of the contract, and the said dates admittedly not designated as holiday. While the communication dated 24/12/2021, petitioner was asked to commence loading and not come for signing of on 25/12/2021. I'll just pause for a moment, my lord. This 25/10/2021, if your lordship looks into it, this is commencement of a signing of the agreement. Kindly see that, my lord, at page. 130, kindly see, my lord. See 130, my lord. The learned single just said that no, there was no signing of the agreement. 130. Kindly see the subject, my lord. 130. Kindly see, my lord. Subject commencement of loading and signing of CA. So at page 373, the learned single judge, with great respect, this is what he's finding. Not desire behind the communication, not to come for signing on 25/12/2021. Apart from what has been stated here in above, relevant to take note, signing of a contract agreement is one thing, commencement of loading operation is another thing. The respondent in the affidavit as well as also in the stay vacating applicant have details that in various other similar contract also commencement of loading operations started even without the contract agreement. Insert tender do not in any manner stipulate the commencement loading shall start with effect from the signing of the contract agreement. It was also seen, it was only on 6/12/2021 a petitioner firm for the first time raised the said issue that without the execution contract agreement, it was not possible to start commencement loading. Whereas all long prior thereto the petitioner given commitment to start loading, it will be very much apparent communication dated 8/11/2021, wherein the petitioner gives a commitment to start loading on 22/11/2021. Under such circumstances, the action of the respondent terminate the contract, so and so and so is no interference is called for. How can I start when there is no allotment? It will be 8 to be. Parameter. Yes. My lord, I see by going to the judgment, great respect to the learned single judge. That's at paragraph 29. But the learned single judge has come to a finding that because clause 8A and clause 8B is a parametria with clause 21 allotment order. There's a parametria with that allotment order. Now the finding of the learned single judge, I have seen that, my lord, that he said once you have accepted the letter of acceptance, so it is deemed to be the allotment of contract. Because there is no allotment of contract. Allotment of the contract is only on 29/11/2021. And therefore, if your lordship kindly see my letter, they only can give when I give the intermediate station at page 114. Their letter, my lord, kindly see their letter, 114. It is not my letter, their letter is 114. Kindly see 26/11/2021, my lord, at page 114. Kindly see the last paragraph. You are therefore required to immediately furnish the intermediate loading unloading point so that the allotment order may be issued according. How can it be, my lord, allotment order, allotment letter of acceptance is deemed to be the commencement of the work? It is their letter, they said. How can you commence it without giving that intermediate loading and unloading points? Kindly look into page 114, my lord, it is their letter. No, this is governed by the terms and condition of the there are certain provision in terms of instruction to bidders. It is unlike different contracts. So this letter, the view of the learned singer with great respect, paragraph 29. I read along with your lordship because I was not going to a judgment, because I am deeply obliged that your lordship has some dates I have missed, man. I am sorry for that, my lord, because I couldn't prepare properly in this case, my lord. My lord. So now this particular judgment which I have read, the judgment, find that with great respect, there was an error that has been made by the learned singer, just mixing with the letter of acceptance is deemed to be the commencement of the contract, which is apparently at page 114 if your lordship looks into it. The letter that has been issued by the railway to us at 114, second paragraph. You are therefore requested to immediately furnish the intermediate loading, unloading point so that the allotment order may be issued accordingly to ensure commencement of lease operation the earliest. So where is the deemed contract, my lord? Deemed commencement of the work, because this commencement date is their own letter. So that is why, my lord, once it was given on 29/11/2021, their allotment order was given to us. So in that view of the matter, my lord, my humble submission before your lordship is that your lordship will kindly interfere with the judgment that has been passed by the learned single judge on the basis of these facts and circumstances of the case. Oh, he's learning. My lord, and one part, my lord, at page 374, the last 5 line which the learned signature has come to a finding that it was not possible. Lordship kindly see the last 5 lines, 4 lines.
Para?
At 374 on top, 374, first, second, on from the
Para,
top
para.
is 31. Continuation of 31, continuation of 31, 374 page.
Yes.
That is first, second, third line. The instruction tender do not in any manner stipulate conventional loading shall start with effect of signing of the contract agreement. It will also be sent, it was only on 6/12/2021. For the first time raised the said issue without the execution, it was not possible to start commencement loading, whereas all along prior thereto, the petitioner had given commitment to start loading, as it is very apparent from the communication dated 8/11/2021, when the petitioner gave a commitment to start loading on 22/11/2021. You have not issued a loan. How can I start? That is why 114 letter. Well, that is why 114 letter, my lord. They said that you please give us immediately the intermediate loading and unloading point so that allotment order may be issued. Accordingly, 29 allotment order was issued, my lord. I saw the judgment legal implication. So that's my submission before Lordship, and about there are 5 judgments on debarment that your Lordship just, I will not read those judgments. Debarment.
Yes, you say that this, they should serve a notice before that.
Yes.
But here in this condition itself, the tender document itself is clearly mentioned that it will be debarred in case the highest bidder fails to take up the starter case, so and so, at least for participating in tender, so and so. That is already there.
No, that is,
Such
my lord,
condition, suppose if the court comes to the conclusion that you fail to start loading or whatever it may be, fails to pick up to start the lease contract, then there is a specific condition that he shall be debarred for 2 years. No such condition was there, then there is a question of issuance of notice or that.
even there are cases where Lordship will find number of cases where the blacklisting provision is there. Even that before taking a blacklisting also notice is mandatory. Even in number of cases, contract. All these cases, minor. No,
Yes,
yes, that's your Lordship. If comes to a finding that your Lordship has indicated that if you come to a finding that this no, it will be counted from 26 learned single judge, the judgment is upheld.
it's a simple a consequential order.
I'm sorry, Manu.
So
Yes,
this debarring is a consequential order
yes.
on account of this, since they
That-
is failed to
Term itself
start
to
the
operate.
lease contract. Therefore, it's a consequential order. It is not an independent action.
But that will have a consequence, that will have a very, that will be a great effect on,
That they have already clarified in the tender document and you accepted it. Therefore, you have submitted your bid. And that's what our presumption is, subject to what you say.
no, any action taken. So for debarment is consequential, maybe there's a clause here. Consequence, consequence. But even that, my lord, they have, but why they have terminated this? What is the action they have taken? One is they have terminated the contract because I could not operate. Then they have forfeited because of termination of contract, they have forfeited a security deposit. Consequent to that,
As per the condition mentioned in the tender document.
consequent to that, they have debarred me for participating in contract for a period of 2 years. That's the 3 points which they have taken, my lord, for terminating the contract. Now, first point A, if your lordship finds that the judgment, on the basis of the submission which I have made, and the judgment of the learned
Then
single,
everything will go.
yes, everything will
Then
go.
everything will go. Whatever it may be
Yes.
department or this forfeiture, everything will go. In that case, everything.
But any action taken by an authority so far a debarment is concerned, my lord. Maybe you may have a clause, but even then a notice is required, my lord. That's my submission for your lordship. That's your lordship will find. That is 2021 to SCC 551. I'll give the judgment. These are all blacklisting, my lord. Natural justice has to be followed. Maybe inbuilt clauses are there, even then a notice has to be given. 2021 to SCC 551, para 15 to 21. We'll hand over, my lord, those copies. Just your lordship can. Okay.
Yes, 2021.
2021 to SCC 551.
Yes.
My lord will kindly say his judgment. Mhm. Blacklisting.
Yes, 2021.
21 to SCC 551. We have given those 5 judgments, my lord. There are 5 judgments which has been given. The last one. What you got it?
Yeah.
There are 17, 18 and 19. 17 and 18. They have quoted similarly this court. What you got it?
Yeah.
Similarly, this court in so and so struck down in order of blacklisting for future contract on the ground for non-observation of principle of natural justice. Relevant extract of judgment in this case is followed. It is the implied principle of rule that any order having civil consequences should be passed only after following the principle of natural justice. It has to be realized that blacklisting any person in respect of business venture has civil consequences for the future business of the person concerned in any event. Even if the rule do not express so, it is an elementary principle of natural justice that parties affected by any order should have right of being heard and making representation against the order. 18. This court in so and so has described blacklisting as being equivalent to a civil debt of a person because blacklisting is a stigmatic in nature and divers a person from participating in government tenders, thereby precluding him from the award of government contract. It has been held thus. It is a common case of the parties that blacklisting has to be preceded by a so-cause notice. Law in this regard is firmly grounded and does not even demand much amplification. Necessity of compliance with the principle of natural justice by giving the opportunity to a person against whom action of blacklisting is sought to be taken has a valid and solid rationale behind it. With blacklisting, many civil and or evil consequences follow. It is described as civil debt of a person who is foisted with the order of blacklisting. Such an order is stigmatic in nature and debars such a person from participating in government tenders, which means precluding him from the award of government contract. In the light of the above decision, it is clear that a prior so-called notice granting a reasonable opportunity of being heard is an essential element of all the administrative decision making, and particularly so decision pertaining to blacklisting which entail great consequence for the entity being blacklisted. In this case, furnishing a valid so-called notice is critical, and failure to do so could be fatal to any order of blacklisting pursuant to that. So entire case, my lord, is notice was required before taking maybe a consequence that they could have done it. Now, Lord, my lord will kindly see 1975, 1 SCC page 70. Munition equipment, that's a famous judgment. That is 1975. What's the right answer? My lord will kindly 1975. Lordship got it? Yes.
Yes.
Paragraph 15, 15, 16, 20, 21. Your Lordship will kindly mark 15, 16, 20, 21.
Yes.
See paragraph 15 by the way. The blacklisting order does not pertain to any particular contract. The blacklisting order involves civil consequences. It casts a slur. It creates a barrier between the person blacklisted and the government in a matter of transaction. Blacklists are instrument of coercion. In passing 16, in passing an order of blacklisting, government department acts what is described as a standardized code. This is a code for internal instruction. Government department make regular purchases. They maintain list of approved supply after taking into account the financial standard of the firm, their capacity and the past performance. Removal from the list is made for various reasons. The ground on which blacklisting may be ordered are if the proprietor of the firm convicted by court of law, security consideration or warrant, or if there is a strong justification of believing proprietor or employee of the firm has been guilty of malpractice, bribery, corruption, fraud, or if the firm continue refuse to return government dues, or if the firm employs a government servant dismiss or remove corruption in a position where he would corrupt government servant. The petitioner was blacklisted on the ground of justification. Firm has been guilty of so and so. The petitioner was blacklisted on the ground they were proceeding pending against the petitioner for alleged violation. The government is a government laws and not of a man. It is true that neither a petitioner nor the respondent has any right to enter into contract, but they are entitled to equal treatment with others who have offered tender or quotation for the purchase of goods. This privilege arises because if the government who is trading with the public and the democratic form of government demands equality and absence of arbitrariness and discrimination in such transaction, so and so treats privilege as a form of liberty as opposed of a duty. The activities of government have a public element and therefore there should be fairness and equality. State did not enter into any contract with anyone, but if it does so, it must do so fairly without discrimination and without unfair procedure. Reputation is a part of person character, personality. Blacklisting tarnishes one reputation. Now, 15, 20, 21, 20 and 21. Kindly see last 20, 21. Blacklisting is the effect of preventing a person privilege and advantage of entering into lawful relationship with the government for purpose of gains. The fact that disability is created by order of blacklisting indicates the relevant authority is to have objective satisfaction. Fundamental of fair play requires person concerned should be given opportunity to represent his case before he is put on blacklist. With regard to the case, para 21, with regard to the case of petition, it is made clear authorities will give an opportunity to the petitioner to represent their case. An authority will hear the petitioner as to whether the name should be put on the blacklist or not. This is made clear. The decision on this question will have any effect on the proceeding pending in the Calcutta High Court, where the petitioner challenged the adjudicated proceeding under Foreign Exchange Regulation Act. Any decision of the authority on the blacklisting will have no effect on the correctness of any of the fact involved in this proceeding. So and three of the judgments, my lord, your lordship, General Clauses Act that your lordship I have mentioned, given there, 2021, I'll just not read that.
Except of this contention that it starts from 29.
Oh, then that's the end of the matter. That's the end of the matter. As a precautionary, well, what I felt, I don't know. But when your lordship was discussing the Honorable Justice Nair, I was just thinking that maybe some against he was just thinking.
Against?
Some against some point against us. I couldn't hear from, I couldn't hear from, your lordship, there's a lighter vein, What the Chief Justice, the Honorable Chief Justice, the retired Chief Justice, he said, very important of a lawyer is to read the judge. When they are discussing, you have to see what they were discussing. One of the senior, there was a senior, he was giving a lecture,
What I have said to
I will not ask.
and he may be supporting you.
I don't know. That's what when Fally Nariman was arguing, Justice Divai Chandrachud was very junior. Then he said, sir, this is a point, you have to argue. Keep quiet. Listen what the judges are saying. What they are going against, what the judge is going against. You have to read that. Don't place that. This is. So I'm deeply obliged, my lords. If any clarification is there, I will just point.
Yes.
May it please your lordship. The lordship may kindly come to page 114, lordship. That 26/11/2021 letter, lordship, by the railway authority, lordship. Here, lordship, the petitioners council have said that the allotment order, lordship, the allotment order, their lordship, interpretation is that the allotment order should be the allotment of the contract. lordship.
Their principal argument is this, that with the issuance of letter of acceptance,
Lordship.
can be said that the contract has been completed.
Lordship,
Until and unless the contract order of allotment is there.
lordship,
So letter of acceptance is altogether different. There is the allotment order.
Lordship.
That they are saying that was of 29/11/2021, and therefore 30 days period starts from that date.
this is not an allotment order, this is the allotment for loading, lordship. That 29/11 is the order for loading, lordship. So lordship may kindly come to page 118, lordship. It's a allotment order of loading, lordship. I don't may kindly subject part, lordship. Allotment order for loading, lordship. It's not a contract, lordship. 118, lordship. Allotment order of loading, lordship. It's not a contract, lordship. Otherwise, it's admitted because of the petitioner is that they have to fail to perform their duties, lordship. For allotment purpose, it is reflected in page 239, lordship. After lordship granting the maximum period of time, lordship, by the competent authority which was granted on 26/11/20 lordship 22 lordship, it should be expired on 25/12/2022 lordship. And lordship that they have, my lord may kindly peruse page 239 for a moment, lordship, their letter, lordship. They themselves admitted that they have failed to perform lordship. 239 letter lordship.
Yes,
If lordship allowed us, then I can read from paragraph 2 itself lordship.
yes, please.
It is to be noted that LOA was provided in the midst of Durga Puja, which is a major festival in northern and eastern part of India. The festival is followed by Eid-e-Milad, Lakshmi Puja, and then Chhath Puja, making the month of October and November a festive season. During this period, most of our staffs are on leave and office are running with bare minimum staff. Also, both the partner of the farm from the Bihar and are busy in preparation of Chhath Puja. As Chhath Puja is the prime festival of Bihar, one of the partner of the farm is herself involved in fasting and puja. Chhath Puja will be over by 11th of November and our staff as well as partners will be ready to mobilize all resources to start operation of the said VSP. Then my lord may kindly peruse. As cited above, it was very difficult to mobilize all resources to start the operation of the said VSP in prescribed time frame. It is the admitted case. They also admitted that when LO was issued lordship, it should be as per the contract, it should be within the period lordship. It is the admitted case. They have failed to perform their duties lordship. That's why they have written to the letter on 8/11/21 to the concerned authority, whereby they have said that we will operate from 22/11/2021 lordship. It is not a case that lordship, they are lordship. Then my lord may kindly come to lordship. Page 148 lordship, the tender conditions lordship. 148 lordship.
One forty-eight.
148 lordship. Condition 7 lordship.
Yes,
This is in respect of lordship security deposit / performance guarantee. The successful tenderers will help to furnish security deposit performance guarantee at the rate of 5% of annual contractual value as per the lump sum lease rate, accepted rate as the lease parcel space or minimum so and so lordship should be issued by the scheduled nationalized bank valid for a period of the contract plus 3 months. Then next page lordship. The above security deposit shall be remitted by the successful bidder within 15 days from the date of the issue of the LOA lordship. And LOA issued lordship on 8/10/2021 lordship. And they have failed to
8/10/2020.
21. They have failed lordship. After the expiry of the 15 days period, another 13 days they have deposited lordship. Then my lord may kindly come to lordship other two conditions of the debt tender condition. Page 157 lordship.
Yes, Lord.
12.0 lordship. Failure to leaseholder to start the operate the lease contract lordship. On allotment of one lordship, on allotment of contract, the successful tenderer will help to start work within a 15 days period, failing which the contract will be terminated and earnest money and security deposit will be forfeited. And then lordship 2. If the highest bidder fails to take up or start the lease contract, he/she/the must be debarred at least 2 years from the participating in the tender in the divisions of the zonal railway lordship. If this debarment is lordship within the zonal or divisional railway lordship, it's not a blacklisting lordship.
Yeah.
And it is a tender conditions lordship which was accepted by the petitioner himself lordship. If it is blacklisted lordship, he cannot participate in other concerned PSU also lordship. It is a debarment for 2 years for violating the tender conditions lordship in respect of the zonal railways and divisional railways lordship. It is not a case of blacklisting lordship.
Yes.
And regarding lordship timeline, well, I am relying lordship paragraph 10 of our affidavit lordship, paragraph 7 and 10. So my lord may kindly come to lordship page 220 lordship. Paragraph 70, Lordship, permit, I can read it again, Lordship. That with regard to the statement made in paragraph 8 of the writ petition, the answering respondent stated that the petitioner was to remit the requisite SDM within 15 days time from the issuance of the LOA. In this case, the SDM was to submit latest by 22/10/2021. As the petitioner submitted the same with a delay of 13 days, the matter was put up to the tendering accepting authority, which is competent to condone the delay in commencement of loading, Lordship. As because the accepting authority was on leave and when he resumed office, the period with divisional power for condoning delay got expired, Lordship. Then, Lordship, the matter was put up to the principal chief commercial manager, headquarter NF Railway on 22/11/2021 for granting relaxation in the light of liberalized policy guidelines circulated by so and so, Lordship. Being the competent authority to grant the extent of 30 days time period for commencement of loading, Lordship. My Lord, may kindly mark it. Commencement of loading, the competent authority has granted the maximum relaxation period on 26/11/2021. This is the, Lordship, limitation period for commencement of loading, Lordship. It was granted on 26/11/21, Lordship, and it will expire, Lordship, on 25/11/2021, 25/12/2021, Lordship. Admittedly, Lordship, in that period, Lordship, the loading was not commenced by the.
Actually, they were supposed to deposit this security deposit by
10
of October 2000, and they deposited on
after, Lordship, 13 days.
on
Lordship, 5/11.
5/11/2021.
And that will be reflected, Lordship, in paragraph 10, Lordship. We have given the, Lordship, date of event, Lordship. If Lordship permit, I can read the paragraph 10, Lordship. If Lordship permit, I can read paragraph, Lordship.
Yes.
So if lordship, I can press only two small paragraph of our affidavit lordship. It is in page 2 to 5 lordship.
Yeah.
It's a part of the paragraph 10 lordship. It's a subparagraph 7 lordship. 2 to 5 lordship.
Yes.
As per 10 lordship, as per 7 lordship, as per tender condition and liberalized policy guidelines issued by Railway Board Circular Nung so and so lordship, including normal 15 days condonation by accepting authority 15 days and condonation by the principal chief commercial manager for commencement of loading is 30 days should be limited to lordship 60 days. Calculation is there lordship. In fact, this 60 days period for commencement of loading applicable from 22/10/2021 and expired on lordship 20/12/2021 lordship. However, the 30 days condonation period within the ambit of principal chief commercial manager was granted on 26/11/2021 lordship. That's why it is counted to 25/12/2021 lordship. And lordship, paragraph 8 also on similar lines. Regarding lordship debarment part, I relying paragraph 12 lordship of our affidavit. Next page lordship.
Yeah.
Next page. That with regard to the statement made in paragraph 13 of the writ petition, the answering respondent state that due to the failure on the commencement of loading of the least BSP on the part of the petitioner, it becomes inevitable to terminate the contract with forfeiture of the SD money along with debarment of 2 years from participating in parcel leasing tender in the division/zonal railway. Lordship, kindly mark it. It is for the division and zonal railway, Lordship. In adherence to the terms and conditions stipulated in the tender document, which was agreed upon by the petitioner by submitting notarized affidavit at the time of offering tender. And that affidavit is page 246, Lordship. My lord, may I kindly come to page 247, last paragraph, Lordship.
Yes.
8, Lordship. We also understand that if the certificate submitted by us found to be false or incorrect or at any time after the award of the contract, it will lead to termination of the contract along with the forfeiture of EMD, SD, performance guarantee, besides any other action provided in the contract, including the banning of the business code. Even they have said that it is for 5 years less. This is my humble submission before Lordship. And Lordship, I also want 2 provision, Lordship, from the Comprehensive Commercial Parcel Policy 2014, Lordship. It is in page 179 to 207. So my lord may kindly come to page 191. I am relying on 20.0 failure of the lease holder to start operating lease of contract, Lordship. 20.1 and 20.2, Lordship, I am relying, Lordship.
Yes.
Yes, sir. On allotment of contract, the successful bidder leaseholder shall be required to commence the loading within a 15 days period, failing which the contract will be terminated and earnest money and security deposit will be forfeited. The accepting authority shall be empowered to condone the delay on the merit of the case or written application from the leaseholder and give another 15 days maximum period to the leaseholder for commencement of the contract. Then Lordship 20.2. If the highest bidder fails to take part or to start the lease contract, he must be debarred at least 2 years from the participating in the tender in the divisions or railway, Lordship. Even yes, sir, Amol submission report.
Yes. Only one last, what my learned friend has shown, 247, page 247. He read one particular aid. When your particular can be terminated for future, I think it is a different context at 247. Fraud, and this is nothing connected with that.
Order is just.
Deeply of placement.
Yes.
Item number 5.
Yes. Well, I took time to obtain instruction from the authority, as I get the response from what steps they have taken as they got for the ROB.
Yeah.
Well, I have been informed by the chief engineer PWD,
Yeah.
that the executive engineer has requested the written letter to the railways twice, but there is no response from the railways.
Why?
Well, kindly come to the my instruction second page.
Read.
11/11/2024.
Yeah.
This is the letter of the executive engineer. He has referred to 2 letters of reference number 1 and 2, 6/9/2024 and 8/11/24. He said that I have the honor to inform you that I have written a letter to DRM NF Railway Lamding Division, Lamding, requesting him to construct a ROB at Bordongpar to make the aforesaid PMGSY road connected to NH, National Highway at Borlongfar. The letter is as mentioned under reference number 1 above, but till now, no any information is received from the DRM NF Railway Lumding Division in this regard. In this context, another one letter has been written to DRM concern, while letter as mentioned under reference number 2, feedback for the same is yet to be received.
But that is to be completed by the railways or by the?
But from the department concerned, the railway has to respond. No? The department, the executive engineer he has already expressed that an ROB is required at that particular place.
Okay. Then only this road would complete up to 15 kilometers.
Road is complete. But road is complete. There is 15.5 is already there. Now they said that to have some the purpose will be served. They said that the interest of the public will be served more if the ROB comes there and it joins the particular PMGSY road to the national highway.
In fact, the grievance of the Krishna. Yes, Mr.
Your Honor, my lord, if there is a railway and crossing, that it will be safety for the people.
Right, but their project was to construct the road up to 15.550 kilometers, whether they have completed it or not.
It is completed in the records.
That they have completed.
Yes.
Because earlier it was said that it was not completed and therefore we issued a direction up to 13 kilometers is what completed. But now if that road is completed, if that is to be some true fare is to be given or something else, that is for the railways to give. What is rural development department?
As per the circular has been given, Your Honor, may I please?
Yeah.
Please,
So it is for them to take up the matter with the railway authorities.
yes, fine.
And for that purpose, they have already written letters, the railway authority. What the Mr. Nath has shown now.
Well, in my instruction, the 6/9/2024 letter is also there, third page, my lord. This is the first request made by us, made by the executive engineer, my lord. He refers that I have the honor to inform you that a road connecting Borlongfar to Lamding via Chotalongfar has been constructed under PMGSY. The road is 15.5 kilometers in length and has become a lifeline road connecting several villages already an airport has been proposed in Karbi Anglong, which also will be connected through this road. However, it is to inform you that a road overbridge only can make the newly constructed PMGSY road a thorough road connecting National Highway at Borlongfar to Lamding. It may be mentioned here that the people of Karbi Anglong district area as well as the district as well as Hosai district area will directly be benefited by the proposed ROB. This was the request on 6/9/2024. So the railway, they have to respond to this. Is there any photograph I think they have given here of map of the road?
This PL petition is filed by the petitioner essentially raising a grievance that the respondent department has failed to complete the road up to 15.550 kilometers connecting a road from Borongepe railway station road connecting Burlangpur to Lamding via total length पर इसको एक बार नोट करते हैं ना total length पर full stop. It is alleged that the authorities who have prepared the project proposal for the said road have not taken into consideration that a railway track dissecting the road near Bolangpur makes the road unusable as the through fare is not provided to bring connectivity to the targeted inhabitants. The petitioner has also prayed that the respondents be directed to take necessary action to provide vehicular connectivity across the barricaded railway track by setting up a manned railway crossing at the spot in the public interest. Stop. On earlier date, it was stated on behalf of the consent of the petitioner that only 13 kilometers of road in question is constructed. However, in the portal of respondent, it is shown that the road up to length of 15.550 has been constructed. Full stop. Later on, it is clarified on the part of the state that as a matter of fact, the road up to 15.550 kilometer has already been constructed. And in support of that, an additional affidavit has also been filed by the state, to which no counter has been filed on behalf of the petitioner. So, Mr. Nath, under consent for the respondent has submitted that so far as regarding the so far as regarding construction of railway under bridge or a manned railway crossing to facilitate the or to provide a connecting facility to the habitants of the people, the executive engineer PWD DP Road Division has already written letters to the railway authorities on 6/9/2024, has already written letter on 6/9/2024, and thereafter have also sent two reminders with a request to either to construct a ROB at Bolangpur to make aforesaid PMGSY road connected to the national highway at Bolangpur Fair, so that the residents of the area be benefited. It is contended that in relation to, it is contended that till so far, there is no response from the railway authorities. Full stop. Having taking into consideration the fact of the facts, having taken into consideration that the 15.550 PMGSY road with the PMGSY concerned road has already been constructed, and for the purpose of construction of ROB, etc. For the purpose of construction of ROB, the respondent or the PWD authorities has already take up the matter with the railway authorities. We are of the view that no further order required to be passed in this PIL petition. However, it is expected that the PWD authorities shall pursue the railway authorities to construct a ROB to connect a ROB at the appropriate place at Borlang Fair to make the aforesaid PMGSY road connected to the national highway at Borlang Fair. Ordered according, ordered according.
Pass over meter 1 and 2.
Lordship praying for an accommodation, Lordship, because he is on Lakes, Lordship. So he requested the matter to be taken up at 10th of December, Lordship.
10th of December, then we'll post it in January.
Lordship.
January 25.
January.
to January. Item number 7.
Make it. Include the order of the learned single judge. Basically is on two grounds, my lord, the challenge to that decision. One is that, my lord, the observation of the learned single judge that there was no transparent or, my lord, criteria for selection for promotion. That is one. The second is, my lord, that no reasons have been recorded by the selection committee. My lord, both the observations of learned single judge with utmost respect are not, my lord, correct. That we will show, my lord. Now, my lord, along with the appeal, I have also filed an IA, my lord, which was for relying upon two documents, my lord, which could not be placed before the learned single judge, my lord, because we could not file our affidavit. The writ petition was disposed of at the motion stage itself.
But in fact, your advocate has stated before that learned single judge that no minimum criteria.
No, because that is the correct position, my lord, because the rules of 2017, my lord, which were unfortunately not placed before the learned single judge, my lord, the
2017.
yes, there are rules, my lord, which I shall place before your lordships. My lord.
What this IA?
No, this IA is regarding two documents. My lord. What has happened before the learned single judge was that the entire selection record was.
There are those documents.
The documents are annexed, my lord, in the writ appeal as Annexure 2 and Annexure 5.
IA for IA for
those two documents, my lord.
those two documents, when they are the part of the writ appeal, then
Yes. Ideally, I should have annexed it with the IA also.
that IA is pending or this?
That IA is pending. There's an observation by your lordship that it will be considered at the time of hearing of the appeal. My lord, as far as those two documents are concerned, my lord, now as far as the 2017 rules are concerned, my lord, these are the Regional Rural Banks Act. Under this act, my lord, these rules have been framed, and these are the Regional Rural Banks Appointment of Officers and Employees Rules 2017. Because if your lordships may kindly come to, my lords, the page 27, which is in fact the third page.
This, just where those rules page number?
My lords, this is the I've only given the relevant part.
Okay, fine.
Third page, my lord, page 27.
These rules may be called regional rule and government rules.
Yes.
Okay.
My lords, these are the rules, and as far as the promotion from scale 3 to scale 4, my lords, that is there at page number 27. That is the third page. My lord. Officer Senior Management Scale, Group A.
Just a minute. Yes.
Yes.
Serial number 4.
Yes, serial number 4, my lords. Officer Senior Management Scale 4, Group A. 100% by promotion, mode of appointment. I feel lordship.
Entire route.
Yes.
My lords, if your lordship comes to the next column, my lord, the selection process for direct recruitment, then the eligibility for promotion. Promotion shall be made from amongst the officers holding the post of officer in middle management scale 3 on full-time and regular basis and having 4 years experience in the said post. The selection shall be on the basis of combined performance in the interview and performance appraisal reports for preceding 4 years. As per the division of marks given below, my lord, the division of marks is given interview 40 marks, performance appraisal is 60 marks. Now, selection of candidates for promotion shall be made from amongst the successful candidates in the feeder grade in order of their merit based on the aggregate of their marks in interview and performance appraisal reports. And my lord, the next column, that is column 9. This is, my lord, the committee shall consist of the following: chairman of the RRB concerned, then an officer nominated by the sponsor bank, an officer nominated by the national bank, not below the rank of assistant general manager. Now, this is in fact the criteria that is there in the rules. So beyond that, my lord, there is no other criteria as such that there is a minimum cutoff marks or anything. So, my lord, the committee and in the instant process, in the instant selection process for the promotion, this is based on the rules only. So, my lord, when the rules do not prescribe a cutoff marks, there is no question. We cannot go beyond the rules and prescribe a cutoff mark. There is only the 40-60 prescription, my lord, that 40 marks will be given for the interview and 60 marks on the appraisal of the performance in the last 4 years in the feeder grade. In this case, feeder grade is, my lord, scale 3. So scale 3 performance last 4 years, his performance is assessed. That is given as the marks from that. and interview, his performance is there. Now, my lords, as far as the transparent criteria is concerned, this is the criteria, so we cannot go beyond that. Now, if your lordship kindly comes to page 17, my lords, what was the notification, my lords, that is there? Page 17 of the writ appeal.
Yes.
Now, this is, my lord, the notification dated 12/10/2022. Promotion process, MMG scale 3 to SMG scale 4. Now, my lords, name of the post, number of vacancies, my lord, 11. Eligibility, officers who have completed 4 years of uninterrupted service in MMG scale 3. Reckoning of the minimum eligibility, the minimum eligibility in terms of the number of years of service for promotion shall be reckoned as on the 1st April 2023. Number of candidates to be considered for promotion, all officers in MMG who fulfill the condition as described under serial number 3 and 4 mentioned herein above. Selection process, the selection shall be on the basis of combined marks scored in the interview and average marks awarded in performance appraisal report for preceding 4 years as per division of marks given below. Interview 40 marks, performance appraisal report 60 marks, total 100 marks. Now, preparation of merit list of successful candidates for promotion shall be made by the committee in order of merit on the basis of combined marks of interview and performance appraisal reports. The number of selected candidates to be empaneled for promotion shall be equal to the number of notified vacancies in the order of merit. Now, this is something which was relied on by the petitioner in the writ petition and also by the learned single judge, that the selected number of candidates should be equal to the number of vacancies. This is there. Reservation of post, my lord, we are not dealing with that, my lords. Now, lordship will kindly come to the next one. As all eligible officers fulfilling the criteria mentioned above may apply for appearing in the promotion process in the enclosed format, application are to be submitted through so and so, so and so. Now, my lord, down below, further, the bank reserves the right to reduce the number of vacancies in case there is shortfall in candidates found suitable for promotion or candidates applying for promotion vis-a-vis the declared number of vacancies. So, my lord, this caveat is there along with the earlier, my lords, this column number 7. Because otherwise, lordship will find that the number of applicants and the number of, my lords, selected candidates, we have not selected all the candidates. We have not, it is not a case where only the petitioner has been ousted. He, my lords, was part of a total of 9 candidates. Vacancies are 11. In the event that, my lord, column number 7 is given its literal effect, my lord, without considering what is there below, my lord, all the candidates who are appearing in the interview will have to be selected, regardless of their performance and everything.
That is not clear, then you have to.
So, my lord, that is there because that further part is there that we, in fact, we do not find anyone
The
suitable.
number of vacancies, that's all.
Yes.
So the bank reserved the right to reduce the, in case.
In fact, the language is.
Candidates found suitable for promotion, candidates applying for promotion. Is the note sheet?
Lordship, the tabulation of marks is at page, my lords, 39. This is part of, my lords, also my, in fact, this is the second document. Because this is the, yes, this is the tabulation of marks.
That we have seen. But why you have not selected these 4 persons or whatever it may be? What was the reason?
The reason, my lord, the
Minutes of the meeting are there.
minutes of the meeting are not there, my lord, because even the rules do not.
Whether their performance was not good, they are not, whatever, A,
Well,
B, C, D, E,
yes, well,
whatever the.
may I,
Yes,
Milord.
you reserve the right.
Yes.
That eligible for promotion. You
Yes.
reserve the right, but there must be some reason not to found them suitable for promotion.
Yes.
And there must be some, for this reason, we are not finding him suitable. Certainly, that decision, you can argue that that is not open for the to judicial review.
Lodge.
So it may be for whatever reason. Even you can say, "Okay, we don't like his face," even though that, give that reason.
Milord, what has happened in this case, Milord, but I've taken the instruction on the issue, Milord, because the rules or even otherwise, Milord, the selection committee was not bound to record any reasons. And the reasons, Milord,
Then,
Milord, this is internal discussion, Milord. They noted it down on certain pages of number. They discussed among
you have
themselves.
selected a person, the person you have selected who performance out of 60 was 52
Lord.
and up to 49 you have selected.
Yes.
Then why these two persons, either you said that their performance was not good,
Basically on the interview part, Milord. Basically on the interview part, Milord, if your lordship sees.
Why these members were not satisfied?
Milord, I am told that they just use some rough pages or whatever, Milord, to discuss among themselves because the reasons are not there.
That leads to arbitrariness.
Milord, the fact of the
Even
matter
if a
is.
person has scored 60 out of 60, then also you may say, no, he is not fit for promotion for what reason?
No, 60 out of 60, Milord, it can only be.
Suppose, I am just giving an example.
No, lordship may fine.
Despite that, you can very well say he is not fit for promotion for whatever reason.
No, it's because the rules of 2017 do not cast any duty, Milord, as such on the.
Even in then, if it is silent, then also the selection committee can have its own criteria for that.
It can, Milord, but in the present case.
Recognized, well recognized formulas.
Milord, in the present case, Milord, there was no such requirement of recording any reasons as such, Milord. And whatever, Milord, I am told that they discussed among themselves and awarded these marks. And the marks, as your lordship will see, are not arbitrary in the sense that the petitioner has been particularly discriminated against.
No.
And Milord, there are 4 others also apart from him who have not been selected. Milord, in total, Milord, this is the, Milord, if your lordships kindly consider one aspect of the matter, that because there was no requirement in the rules as such, and there are judgments in the Supreme Court I shall place, Milord, that when the selection committee is not required to record reasons, Milord, it may well not, Milord. Yes. No, my lords, on the issue of whether, my lord, they are required to record reasons, my lord, I would place certain judgments on recording that lordships may consider.
At least, on what ground we may say that since the officers at their whims has not found any person suitable and
No, it's not at the whims, my lord, it is not there. Basically, no, actually what has happened is that because the rules are silent on the issue and the rules do not require any.
Then the selection committee can always fix a criteria for that, sir.
That criteria unfortunately is not there in the 2017
Then
rules.
you can't take records of that, sir.
That is the issue, my lord. The rules as such do not prescribe any cutoff marks, nor, my lords, there is any recording of reasons.
If the rules are silent on this aspect, the selection committee can very well roll the criteria for that. That is permissible.
But the selection committee in the present case would be going beyond the rules, my lord, then in that case. The other aspect would be, my lord, that the other persons who are not selected, they may also now claim that they have not been, they are not reasons, and the entire process will get. That is the difficult, because the rules as such, the twofold problems is there. One is that there is no criteria prescribed other than what is there in the rules, that 60-40 aspect is there. The other aspect, recording of reasons. Now, Supreme Court is very clear, that.
Thing of that, rightly said. Record produced and reveals that there is no cut-off or fixed or consideration of condition after who appeared in the paper selection. As a matter of fact, rules do not permit fixation of such cut-off or therefore. A careful exam, record the section board is not criteria. That we saw. Above action on the part of the denying promotion without applying the transparent and reasonable criteria.
Yes,
At least the
transparent and
reasonable criteria must be there.
Transparent and reasonable criteria, the selection committee, in my humble submission, would not be competent to fix, because the rules are not.
They can.
In that case, then the entire selection process will be now in jeopardy, because it will be very difficult to recast, because the selection committee was under that.
And ultimately, in this case, on 20th of June, this order was passed and he was going to retire on 30th of June 2023 after 10 days. This was the only position.
Yes.
And the promotion would have given him a retired benefits. And just 2 months, my lord, he would have retired in a scale 4 post, which every officer once had the tag. And just an ego.
There is one more aspect of the matter, the Supreme Court also says, that the High Court ordinarily should not direct promotion, it should direct consideration for the promotion. There are also judgments to that effect, but here, promotion has been directed. Now, other parties involved, will come into the picture, and they will also claim the same equivalent right, who have not claimed so far.
They have not claimed so far.
They have not claimed so far to our knowledge.
They may not claim.
No, that is there, but the entire selection process will be in jeopardy, because otherwise,
Entire selection, the denial of promotion to this person without following a transparent and reasonable criteria is the only thing.
but as far as the stand of the bank is concerned, the criteria is that the marks have been allotted under each head. And as far as the performance appraisal is concerned, it's a very subjective thing, because the preceding 4 years service is considered.
Show us that his performance in the last preceding 4 years is not shown.
That's what that
Presume that.
I'll have to produce the original
presume
records for the last 4 years.
Ultimately, his performance was not good, therefore it's good within that he may not fit for this.
For that, the records or the original records of last 4 years of all the candidates will have to be gone into in that.
All the candidates.
Then we'll produce that.
My lord, for the performance, he has been given 43 marks out of 60, my lord. Annexure 5. Performance appraisal report of 6 out of 60, he was given 43 marks.
Pension is entire pension.
No, he's getting.
No.
In the bank regulations, pension.
Yes.
provision is-
Yes.
Pension, gratuity, my lord, by this promotion, you would have had a better retirement benefits.
Instead of scale 3, he would be scale 4.
He retired as scale 3, you would have got scale 4.
And it will be very difficult under the circumstances. The other petitioners are also there, and the service records going through that.
They are entitled for, we can't say only on account of this, the others will also demand.
As far as the appraisal part is concerned, it's a very subjective thing. So that is that's that aspect.
Thing, but please, appraisal part, there must be some. What is this for?
My lord, it is the entire rules. Now, if your lordship takes up the rule, lordship will see it is based on marks in the appraisal and the marks it is a total out of 100, whatever he gets. Now, there is no cutoff mark set. So, my lord, if there are 11 vacancies, my understanding of the rules is that posts will be filled up on the basis of marks, and the last person who comes within the vacancy will be selected or appointed, and then the others will follow. Here, my lord, in absence of any cutoff mark, my lord, how do I have, how they have
Which
decided that
situation you
not
have
selected?
to, Clarify the position you have to.
That is why, my lord,
Area for-
no, but that is why, my lord, in the notification itself, it was specifically stated at the end, that further part, that if they are not found suitable for promotion, then the number of vacancies shall be reduced. So 11 of, instead of 11, we have given 5. Otherwise, my lord, the
Why they
select,
have not found suitable, sir?
no, that is,
Not found suitable simply by saying that why they have not found suitable.
no, that recording of reasons, my lord, they were under the impression that the rules do not require, my lord. So that is why, my lord, so no such reason has been recorded.
Even the vacancy position has not been changed, my lord. If your lordship takes up page 39, the minute shows that 11 vacancies were taken into account. Lordship will have a look at
Only
page.
9% were eligible for that.
Yes.
At that time.
Yes,
at the time
9%.
in
So
the-
in absence
the
of any
interview.
cutoff mark, the basis on which they have recorded so and so selected and so not selected. There is no cutoff mark. So their entire process is in violation of the rules itself.
Close for all.
Item 9.
May it please your lordships. This. May it please your lordship. Lordship, this appeal is against the judgment wherein we are challenging a part of the judgment, wherein this honorable single judge has actually substituted the punishment with a different punishment. Basically,
Same position.
no, he has put it from the day the judgment has been.
That
Though
extended the
Yes.
date of compulsory retirement.
date of compulsory retirement has been extended from the date when, and in the other hand, your lordship, the order has been set.
Interfered.
So the ultimately the punishment, even though it was found to be illegal, Ultimately, punishment was again given. Normally, your lordship, I'll just come to the judgments and other facts. Normally, what has happened?
The most you have agreed by this, no.
Yes.
No pay. That was the, your grievance,
My grievance is that, yes,
the
the,
back wages, 2009 to 2023.
yes, and the compulsory retirement. Normally, what happens, your lordship, when there is a setting aside of a, your lordship, order of termination by whatever way, then the normal course is to reinstate with back wages. It could be full back wages or whatever, that is a
But the
separate, different matter.
Has given reasons that since you were.
That is where my case lies, your lordship, has given that he is 53 years of age at this point of time. Now, how there was your lordship, any allegation from any side that this person is not fit or something like that. At best, your lordship, the reinstatement could have been made. I'm just making a point. Reinstatement have been made. If they find that this person is not fit, the respondents are very well can have a board, medical board, and find out whether he's fit or not. And then if he's not fit, they could have put him in some other. But how can the court, without there being any pleadings here and there, found out that no, since he's 53 years of age, he will not be fit? How can that be? That part is where I am agreed. And secondly, your lordship, with regard to the back wages part, he said no work, no pay. No work, no pay also. I have some judgments, your lordship, which I'll place. It is not that the court in Supreme Court has earlier said in a very leading case of Dipali Gundu Survase, where it has been laid down the guidelines how it has to be made. The first thing is that once you set aside an order of termination, if finding it illegal, then the person who cannot be punished for the illegality done by the respondents. Here it is like he has been punished for the illegality done by the respondents. In fact, the punished for what? The illegality done. They have not allowed me to work. They have terminated bus service by compulsory retirement. Because of that, I have to suffer. First, the penalty was reduction in that your lordship will find.
In the judgment itself, it is reflected, my lord, in page 283, my lord, para number 3. Para number 3, my lord, in the judgment itself. It is reflected. CRPF rule in the middle, my lord. When to impose penalty, reduction of
Two stages in time scale. And thereafter it was enhanced to compulsory retirement. So that part, your lordship, with regard to the compulsory retirement, both the parties have not challenged that. We are challenging with regard to the only second part.
What is the order of the revisional authority?
Page 91, my lord.
21. Effective means that you were convicted by the competent criminal court.
Initially, there was a conviction. In the appeal, the conviction was set aside and I was
Right now,
At the time of
conviction, 385, 34 was, you were acquitted, but for another offense, you were convicted.
yes, but that was for trespass, Your Lordship.
Wait, maybe.
Yes, that was there, but
Criminal
subsequently,
criminal charge was there.
yes, but ultimately when on appeal, I was given allowed to go on provision of Offenders Act.
Whatever it may be, conviction was, conviction remained there.
Yes, that part, your lordship, one thing, actually what I'm trying to say,
Conviction remained there.
that is there. That is there, but ultimately I was allowed to go on that. Number one,
Why a person was convicted by a criminal court for an offense, even though for trespass, we allowed to continue in this police force, sir.
no, that part, your lordship, who has challenged your lordship,
This is the fact.
no,
This is the fact. We can't
that is,
ignore
that
it.
is with regard to
We
the.
can't ignore it.
No, I'm not saying ignore your lordship, but your lordship will have to go to the enquiry report. What the enquiry report says, your lordship, the enquiry report says that
Please. Inquiry report, you cannot challenge the findings of the inquiry report at any point of time.
no, obviously not, because it was in my favor.
No.
Only point that was in against me. No, there was no, it is not been established that I have demanded money.
Now
Number
let
one,
us come.
only
Now
thing,
let's Come
yes,
to single judge law.
yes.
Come to single judge. Absolutely.
Lordship will see.
Just a minute. Para number 13.
Yes.
Read.
From a careful reading of the report submitted by inquiry officer, it appears that although the allegation of having demanded money from the complainant by the petitioner and his colleague could not be established, yet the finding of the inquiry officer to the effect that both the constable has gone to the residence of the complainant so and so on the day, so date and time mentioned in the complaints appears to be well established. Be that as it may, since the writ petitioner has not questioned the findings recorded in the inquiry report dated so, nor he has challenged the original order of penalty, it would not be necessary for the court
You
to
have not
consider.
challenged the finding of the inquiry report?
Yes, we have not challenged
the original order of
No.
penalty.
no, we have only challenged the compulsory retirement.
Compulsory retirement enhance that enhanced punishment.
Yes,
While exercising the revisional power.
yes.
And your principal argument was that that was barred by limitation.
That was, one is
That
barred
was
by
accepted
limitation.
by the-
Second, there was
That
no,
was accepted by the learned singer.
second point that was given was that there was no specific grounds given by the revisional order. Anyway, these two are the grounds.
These two are the grounds.
Yes.
But the learned single judge exceeded this notice that you were convicted by a court for a criminal charge.
Yes.
That has been escaped.
No, I have been convicted to that extent.
Whatever extent convicted means convicted
Yes.
for this offense or that offense, you were convicted.
Yes,
And that conviction still holds good.
but I have been allowed to go on a provision of Offenders Act under the provision.
Conviction is altogether
Yes.
different part and sentencing. and
Exactly.
conviction of offenders is different.
Exactly.
Conviction is there.
Yes.
So why a convicted person be allowed to reinstated in the service, sir?
Reinstated in services, your lordship, when this court has found that there is an
Why-
illegality.
why-
No, no, we are,
exercising
not in the
equity
criminal-
Jurisdiction,
yes.
why should be, this court should allow this person to be continued in service?
There are two options now, argument on this we have. Number one, what has happened, your lordship? What has happened? This is a the departmental inquiry. Whatever the departmental inquiry has been found is being, is before your lordship. The criminal part is there, fine, we are not on that. Now, the criminal part remains. We are not challenging that. They have also not brought out that we are not, nobody has brought in that. Only thing that came before your lordship was whether the compulsory retirement was correct or not. That was, this court found that no, it is not correct. So it has been set aside. Fine. If it has been set aside, what would have happened? Even if that conviction part remains and the court, the earlier order, that earlier order of reduction in the 2 stages in the time scale of pay was given, that would have been there. We have not challenged that, that would have gone back to that stage.
That's
But-
same,
Mm.
but for the purpose of continuation in service,
Yes.
why this person? is
Then
allowed to
who-
continue in service when convicted?
How that can be decided, your lordship?
They
When that is
decided if
neither
by-
here
by
nor there, nobody has pleaded that.
Exercising extraordinary powers and equity jurisdiction. This court can take cognizance of this fact itself, sir.
That can be taken, your lordship, but what court has done? Compulsory retirement was set aside and brought back
There
to
are
the,
many things. In fact, these, on a first, glance, we are also not agreeing with this, we are not in perfectly agreement with this Madras High Court judgment on which the learned single judge has placed reliance.
that is the, that we have
And
not,
apart from that, section 29 specifically says that in a case, that delay can be condoned by the revisional authority. That is also there.
yes,
So it's not that delay can't be condoned. It is there,
yes.
it is there. So why don't we deem it as it is that while the revisional authority has condoned the delay and then pass the order. There are
That,
many things.
yes, lordship is correct to that extent.
Better.
My issue was that second part was with regard to the period of till the date when his compulsory retire, that has also been waived out by saying no work, no pay.
Yeah, that is right. No work, no pay. Yes, you can very well say that you are willing to, but they restrain them, this respondents have restrained you from
Yes,
discharging the duty. You can very well
that
say
is what I actually, even the judgment that I relied was on that point itself.
equal pay for the equal work.
That is one point, your lordship, because
Many things.
because the,
Better, what we feel, it's better, it's a very good order. If you are favor, don't get it. Otherwise, we'll again, either we'll interfere with this order, will remand the matter to the learned single judge again. Then many things will again come.
that is, your lordship. Earlier also, this matter was heard and it was CAV, then again it has come up. Lordship, Justice Mehta and the division bench heard. So second time I'm coming up. Somehow that order was not passed. Anyways, lordship may be correct to that extent, but only issue, your lordship, two issues have happened. We did not get any benefit from the order here.
You get every benefit, sir. Your service.
Pension period,
In fact, you'll get all the pensioning
Pension
benefits while treating you in service up to 2023.
That is true, your lordship, but what happened after these 7 years which are left for the, that is one part, your lordship.
Yeah, another job. Or you are doing something from last 2009, you were out of job.
And this person is from Bihar, your lordship. And even coming,
He's from Jammu Kashmir.
no, whatever it is,
Bihar,
your lordship.
Assam, how it
I
belongs
cannot
to
take,
India.
that
He's
is
a
true,
Indian
that is
citizen.
true. He is an Indian citizen. He was working here. He's from Bihar. This has happened. Even I have, he rang me up, I think 3 days back. I asked him whether you're getting the pension which the order has given. Even that pension has not been given till date.
That we can order. That we can order.
In fact, if your lordship thinks that way, I'm not going to force upon your lordship, obviously not.
There is no question.
So only,
Just
only,
we are deliberating.
yes, exactly.
What we are doing, we still don't know. We are just contemplating. Then we are not clear what we
Yes.
are doing.
This is basically, your lordship, the fact that holding 53 years, that part somehow, I don't know how the court came to a finding.
Given case.
Your
yes,
lordship
you
is
are right.
correct
In a
with
given case, you are right.
Yes. সেইদিনা হোৱা হলে সেইটো পৰিস্থিতি একদম ফেভাৰত আছে Yes.
The first and foremost question, the current single judge has interfered with the order of compulsory retirement only on the ground of delay.
Really?
There's,
My lord has already, we don't subscribe. The decision, because 29D is a separate provision.
Mhm.
When you apply for revision, C to E of that 28 happens. And again, E says, even if you apply with delay, the appellate authority can condone it. Right? So on that count, if we now interfere, the compulsory retirement gets revived. If that gets revived, you are taken back to 2009. So your pensionary benefits will be counted from 2009. This 13 increments plus one revision that you get,
Mhm.
you will lose.
exactly.
You will lose. One. Two, 2007, 9, you will not be at 2009 stage because that earlier penalty will kick in. You will go back to 2007. So calling our interference in this may not be in the interest of the, because they have not filed an appeal.
They have not.
So we are not going to,
The,
if you are, but if you invite us to on merit, we'll have to go into this question.
Many things we have to.
We have to go in.
Lordship is correct. To that extent, I understand.
I have already said that the pension, we will fix a time limit. The 3 months.
Grant them.
That will do, I think.
Yes, sir.
That will do. Because this is also lack of your lordship, the appellant to elect. Because what your lordship is trying to point out, I understand that. Because what happened, yes, exactly, I understand.
One way.
Yes, but that is also a way, which is correct, not that, no doubt it's not correct. But whatever he has, the single judge has done, that is, I'm not on that, nobody is on that. Basically, I was only on this ground, two things, your lordship, with regard to the no work, no pay, zero. And the second part was with regard to the 53.
Single judge, based on the equity and.
Yes.
Some considerations have not thought it good to reinstate you in the service and therefore we extended this date of compulsory retirement.
Yes, exactly.
And with the this condition that all the other benefits pensionary will get all.
53 years, your lordship, actually, if we see, it's not that.
Even though
This civilian-
nowadays 60 is also not a good.
But this was what your lordship, when we argued for the first time, this was what the honorable division bench pointed out to him. But somehow the judgment was reserved, could not be delivered.
A civilian.
But anyway, that
employee
was
and
something
this
else.
Commandant soldier, matlab, say he was a Havildar, matlab, and ordinary civilian employee, and there's a difference. Matlab.
Please don't argue much.
No, matlab. I am not.
Nothing to say. And you have not even challenged that it is ordered by way of appeal. Don't argue much.
Your lordship may not take it as your lordship argument accepting this proposal. That's it. Basically, with regard to accepting that, yes, since we are not going to interfere with the single judge judgment.
Enter into the merits.
No, I'm not saying into that, your lordship, but at least I have
Complete your
accepted,
instructions.
I have accepted your lordship's proposal.
No, you complete your instructions by tomorrow. We'll place it, fix it tomorrow. Complete your instructions since you are in contact with it.
No, lordship can, because I personally has informed him that this order otherwise is not a bad order. I informed him. So, but since your lordship has placed it, I am accepting it on his behalf, your lordship. There's no difficulty on that. I am accepting it. But your lordship may not.
The order would be, okay, you have, after arguing, you have withdrawn. But the pension, there will be direction.
Yeah, that part is more important. That is what I'm trying.
That will give a direction.
Then your lordship, I'll accept this.
So this directions given by the learned single judge regarding payment of this pensionary and other benefits. Be made within a period of 6 months along with payment of arrears, if any.
Yes,
That we can.
that is acceptable.
This writ appeal is preferred on behalf of the appellant being agreed with the order dated 26/8/2023 passed by the learned single judge in writ petition number 2783 of 2018. whereby the learned single judges partly allow the writ petition filed on behalf of the appellant and has interfered with the order of compulsory retirement passed by the respondent number.
This is respondent number 3, Your Lordship.
Of respondent number Inspector General. of Police,
Inspector of General Police.
passed by the Inspector General of Police, CRPF, Northeast Sector, Shillong, Meghalaya. Who was exercising the revisional powers under section 29, under rule 20. Rule 29 of the CRPF Reserve Police Code Rules 1955. Stop. While interfering with the order passed by the respondent number 3, the learned single judge, while taking into consideration the fact that the appellant was out of service from last more than 13 years since the date of passing of the order of compulsory retirement dated 22nd of February 2009 and is around 53 years of age on the age the order of reinstatement in services cannot be they cannot be passed. Full stop. The learned single judge has observed that for the ends of justice and for balancing the equities,
Deputy.
it is ordered that the petitioner that the appellant shall be notionally treated in service till the date of the judgment and the pensionary benefits of him be recomputed, whereafter the arrear pension be released after adjudging the pension, if any, already paid to the petitioner as per the as per the punishment order dated 22nd of October 2009. This also ना impugned order 22nd of February किया था उसका अक्टूबर आएगा पहले ऊपर हुआ क्या है अभी just ऊपर पड़ा The learned single judge just clarified that in other words, by virtue of the order, the petitioner shall be deemed to have retired from service, that is from the date of judgment. The retired, that is from the date of judgment, that is 28/6/2023. The learned single judge has also denied has also denied the claim of the back wages of the appellant on the salutary principle of no work, no pay. After attempting to argue the matter for quite some time, the learned counsel for the petitioner has submitted that the learned counsel for the appellant on instruction has submitted that he does not want to press this petition since the order impugned is passed by the learned single judge on equities and for the and to meet the ends of justice, However, he has paid that. So far as regarding the pensionary and other service benefits of the appellant, the respondents be directed to pay the same and clear all the dues within a time frame.
3 months, your lordship.
Within a time frame. Full stop. At this stage, learned counsel appearing for the respondent has fairly submitted that the pensionary benefits and other service benefits, if not paid to the appellant till date, shall be paid within the time frame fixed by this court. We could stop. In view of the above submissions, this writ appeal is dismissed as not pressed. However, the respondents are directed to fix to pay the pensionary benefits and all other service benefits to the appellant as directed by the learned single judge within a period of
3 months.
4 months, ma'am.
4 months, 4 months from the date of production of certified copy of this order. If not already paid, if not already paid, 4 months so and so. If the service benefits are not paid, if the pensionary or other service benefits are not paid to the appellant within the above time frame, within the time stipulated, the respondent shall pay the interest at the rate of 9% per annum on the delayed payment.
That impugn order 22nd October, but by Rasul number 4, not by.
Not 3, 4.
Respondent number 4. Not Inspector General of Police.
No, it's by Deputy Inspector General. Appellate order by the inspector. But all right.
Service benefits, pension and pensionary. Pension and गांजा पे भी है ना सर्विस।
Item 11.
Lordship, I have come against the judgment,
Yeah.
the Honorable Single Judge, Lordship, passed on 28/4/23, Your Lordship. Lordship, the factual matrix is this, Your Lordship.
Still matrix we are aware of.
Lordship, the judgment, the relevant portion of the judgment, Your Lordship, of the Honorable Single Judge, is at page 109, Your Lordship. There are number 26, it starts from page 108, Your Lordship, but then the relevant portion is at page number 109.
Yes.
It starts from the 8th line, Your Lordship.
Read.
This court further, in order to clarify as to whether the district elementary education officer was the appointing authority in terms of the rules of 1977 at any point of time, inquired to the learned counsel for the petitioner as well as the respondents. However, no provision was shown that the district elementary education was an appointing authority at any point of time in terms of the rules of 1977. Under such circumstances, the order of appointment dated 6/12 1999 in favor of the petitioner having been issued by the district elementary education officer. The same was not in accordance with the rules of 1977, so also the Act of 1974. But then, actually, at the relevant point of time, Your Worship, in the year 2099, the elementary education officer was empowered to issue appointment letter. Very good. These are the rules, Your Worship, and these are extracted from this book. Your Worship. Only one book is available, Your Worship, in the library. That extract, I have highlighted the extracted portion, Your Worship, in the paper size, Your Worship.
This is,
In the fourth page, Your Worship.
this is the,
I have extracted, photocopied this from that book, Your Honor.
from that book.
Yes,
Try to go through the book.
in the fourth page, Your Lordship. Page number is 19, Your Lordship, internal page, down below, Your Lordship. The third line, Your Lordship, starts. The Deputy Inspector of Schools or the District Elementary Education Officer, as the case may be, shall appoint the selected candidates in order of merits only from this authenticated select list. So therefore, the District Elementary Education was empowered, Your Lordship. And the Honorable Single Judge made an error of judgment, Your Lordship. Not having a look at this, Your Lordship. Moreover, Your Lordship, moreover, Your Lordship, may come to page
So this rule says that we are referring to this, the director shall authenticate and get the select list to prepare, published by everything copy thereof in the office of the notice board of the director elementary education account. Respect of the school district elementary, the dog officer and discipline in any other manner, government may deem it fit. When the receive the different subdivisions, the select list containing the result shall be public document and shall be available to the bona fide member of the public on application with such requisite fees as may be determined by the government from time to time. Where is that list?
Lordship, Lordship may
There is
come
the
to,
authenticated list,
Lordship may come to page 26, Your Lordship.
26,
Yes, Your Lordship. There is an order from the Under Secretary,
26.
26, starts from 26, Your Lordship.
Read.
This is a letter from the Under Secretary,
Yeah.
Government of Assam, to the District Elementary Education Officer to release the salary, your lordship, that this,
Leave it. You just show the list, release the salaries afterwards. Show the list. Where is that list?
that list I don't have, your lordship,
You
but
don't have
then,
this, then.
but an appointment letter is there at page 24, your
No,
lordship.
even if your name was not figured in that list, appointment order was issued by the district elementary officer and that would be treated as valid.
But then
Even though
that,
your name was not in that list.
that,
Without,
that list is not available with me, your lordship. That's
sir,
why
that
I
was a public document.
But then there is an
The
appointment
thing on
letter.
which you are placing reliance, that is a public document and available to all the public. The
Uh,
select list containing results shall be a public shall be public documents and shall be made available to bona fide member of public on application with such requisite fees as may be determined by the government from time to time. You should have obtained that list. It was available for everybody.
That was not done, your lordship. But then there is an appointment letter pursuant to
Appointment
the
letter, sir.
pursuant to the publication of the list, your lordship. There is an appointment letter at page 24, your lordship.
Yes, this is the appointment letter.
This is the appointment letter, your lordship,
Where is that,
at page 24. Appointment letter, type copy is at page 24, your
Where is
lordship.
that list?
That list I don't have,
Subject
but then
without notice, without assigning a reason and therefore on the interest of public service, Srimati is selected candidate by sub-divisional officer hereby appointed as so and so plus other allowances under the rules posted at so and so, she should join a new assignment within 24 days. Sir, where is that list? Which is that list?
that has been endorsed by the government, your lordship, at
Huh?
page 26. That action of the district elementary education has been endorsed by the government, your lordship, the
Without
undersecretary.
questions, sir, I'm directed to request you please release the 58 facilities of.
So therefore,
List example.
unless that was done pursuant to a select list, your lordship,
You just show.
that has been,
Sure, you
that
are
has been
presuming,
endorsed.
you are presuming that since the appointment order is there, therefore that.
But then that
there
has
must
been
be a
endorsed,
select
endorsed by
list.
the government, your lordship.
Huh?
That has been endorsed by the higher authorities, your lordship. That the salaries are to be released, your
That
lordship.
list is a public document. Show us that public document.
That, at the moment, I don't have, your lordship.
And if that is so, then file a review petition before the learned Singh that this was the provision, how you have mentioned it.
Lordship.
If you are claiming that in this rules of 1977,
Lordship.
the district elementary education officer is the appointing authority. Show it to the learned single judge.
But then the order has been passed by the single judge, your
So
lordship.
that's why only file a review petition that there is a apparent error. File a review petition.
But then when the appellate court is, your lordship.
Appellate court, since there is no such even before the learned single, there is a apparent error. This court further on, in order to clarify whether the receipt was the offending or the terms and so it inquired with the learned consent of the petitioner as well as the respondent. However, no provision was shown that there was an appointing authority at any point of time in terms of rules of under such circumstances order. You have not shown any such order. Any provision under the law. Have you undergone any junior basic or normal teachers training?
No, your lordship. No. Because I was not sent, your lordship. That's
Huh?
why I was not sent by the school, your lordship. That's why I couldn't.
Sent by the school. It means you are not at all
I
in the
must have,
school.
I must have to be deputed, your lordship.
So it means you have never been appointed.
The appointment letter very well shows the, your lordship.
But the
And that has
appointment
been
letter is
endorsed
there
by the
that you have
government, your
not been
lordship.
sent for this junior basic or normal teachers training. It means you are not in service.
But unless I am sent or deputed for the training, it is not possible on my part to go, your lordship. If your lordship comes to page 54, your lordship, and another similar situated person, your lordship, got all the benefits, your lordship. In the same list, your lordship, this list which starts from the list sent by the undersecretary to the district elementary education officer. There is at page 54, your lordship. It starts from 52, your lordship, for a release of salaries of 58 number of employees, your lordship.
Yes.
At page 54, at serial number 45, on Manav Nath. He was given all the benefits, your lordship, after having, after his having a process honorable court, your lordship. And my name is at your lordship, 54. Moreover, your lordship, at no point of time, my services were terminated, your lordship.
First of all, you satisfy about the appointment, then the question of.
I was allowed to serve till 2021, from 1999 till 2021, your lordship.
And you
And-
approached the court in the year 2017.
Lordship,
You filed the writ petition in which year?
that was in 17.
So 99 to 2017, you worked without any pay.
Yes, your
Why?
lordship. Till 2021, I served, your lordship.
Yes, you
I have
served
my
up to-
attendance as
You
assigned.
served up to 2021. But for the first time you approached the court, you were appointed in 1999 and you were not paid a single penny.
No, your lordship.
And despite that, you kept quiet up to 2017 and then only 2017 you approached the court. That salary, please give me the salary.
No, then, because I was supported by my husband at that moment of time, your lordship, that's why.
So
Because,
2017, he stopped you supporting.
no, thereafter, I had estranged from my husband, your lordship, that's why.
Then he said that suppose if you have not been estranged from your husband, you will never ask for the salary.
But that's a different thing. Yeah.
Different thing, that's the only thing.
But then I was not paid salary for 22 years, your lordship. And my services were utilized, your lordship. And the apex court says, your lordship, when my services were utilized, I must have to be paid. Without the apex court judgment, your lordship. When my services were utilized, your lordship, for a long 22 years, without terminating my services, your lordship. And there was no any
There's no question of communication and publication. They were.
There was no
Your case
termination
is-
because I was allowed to serve your lordship.
Your case is that you were
I have been
your
serving,
services have not been terminated.
not terminated, your lordship.
First of all, satisfy us that where is the appointment? List, where is the select list?
That selected is doesn't, I have, the respondents may be directed to produce the,
You approach this court that pay me the salary, I was selected on so and so post in so and so date. And now you are asking that this respondent should build your case. How can it be, sir?
lordship may allow me some time, your lordship,
For what?
for getting the select list.
Now enough time is granted.
But then on humanitarian consideration also, your lordship, my services were utilized for 22 years and I have not been paid a farthing. And the Supreme Court also says, and my appointment was after a selection process, your lordship. And
Close for orders.
apply those.
Item 13.
I am aggrieved by the order passed by the Learned Cat Central Administrative Tribunal at Guwahati, my lord. I am aggrieved by the order passed by the Central Administrative Tribunal at page 67.
Yeah.
Whereby on the very first day itself, the original application was dismissed on the ground that the petitioner here did not bring out any legal point. And he was not,
If there is any bar in deciding the, where the first.
no, there's no bar, there is no bar.
It can be a ground.
And another issue, my lord, is that on, my lord, may kindly peruse the order dated 7/8/2023 passed in this case, my lord, wherein they this the order of this court, my lord, on 7/8/2023.
7/8/2023.
Para 5 of the order, the the learned counsel for the petitioner, para 3, has submitted that the original application was disposed of at the motion stage on the basis of instruction produced by the respondent. However, without considering whether the petitioner was in zone of consideration and whether his candidature was required to be considered when the last suitability test was conducted on 26/11/18. Accordingly, the court finds the issue raised by the learned counsel for the petitioner requires adjudication, and accordingly, the writ petition stands admitted for hearing by issuing rule returnable forthwith without requiring the petitioner to take fresh steps. The respondents are directed to positively file their affidavit in opposition, specifically with regard to the projection made by the petitioner that on retirement of Babul Kanti Day on 31/8/2018 from the post of senior technician, the case of the petitioner was required to be considered for promotion. So in this case, my lords, prior to my retirement, the petitioner had retired on 28/2/2019. Prior to that, the petitioner had submitted an application that he may be considered for promotion to the post of senior technician.
What happened to that?
That was rejected by order dated 26/3/2019 at page 50,
Read
50.
the order.
Page 50 is the impugn order which was passed, which was challenged before the honorable, before the learned Central Administrative Tribunal at page 550, my lord.
Read the.
With reference to the above, it is to inform you that in terms of DRM office order number so and so, Sri Rohit Das Basak has been promoted to the post of technician 1 under the cadre restructuring benefit with effect from 1916. As per the selection calendar for the year 2018, the last suitability test for promotion to the post of senior technician category has been conducted on 26/11/18. In terms of para 212 of REM, the suitability test should be held at the interval which should not be less than 6 months. Moreover, as on 1/4/2018, there was no vacancy in the category of senior technician FPO. So the question of promotion to the post of senior technician of Sri Rohidas Basak does not arise. So this order was put to challenge before the learned tribunal. This was rejected, and against which we have filed this writ petition before this honorable court. My lord may kindly peruse at page 46 of my writ petition. This is my lord Babul Kanti Day. He was a senior technician. He retired on 31/7/2018. Thereafter, my lord, Deepak Chakraborty, after his retirement, Deepak Kumar Chakraborty, he was also promoted. He retired on 31/12/2018. So in the impugn order which they have passed, they have stated, my lord, that the last test was conducted on 26/11/18, and thereafter there was on moreover on 1/4/18 there was no vacancy. If that be the case, my lord, then Mr. Deepak Kumar Chakraborty could not have been promoted and then retired as senior technician FPO, my lord. And I on 1/1/2019 I was in service. So I had submitted my application.
That on which date?
I retired on 28/2/2019. Prior to that date, I had submitted 2 applications before the concerned authority. They did not consider the said representation. So for that matter, this order was passed whereby they were directed to specify as regards the specific assertion made by the petitioner. Their affidavit which they have filed, my lord, they are silent about the assertion which we have made as regards Babul Kanti Day. If my lord may kindly peruse their affidavit filed by this union. Para 6 of the affidavit at 103.
Just stop.
Have you cleared that suitability test?
I was not considered at all, my lord. Because I was,
And these two persons, Babul Kumar, Babul Gandhi, and Deepak Kumar Chakraborty, they have cleared the suitability test.
that information I do not have, but they were promoted, my lord. That
Means
information,
they might have cleared.
that might have,
They have not conducted the suitability test in your case.
yes, my lord.
So without passing that suitability test, how can you?
But they should, because prior to that, my lord, we have submitted our application, my lord. My lord, may kindly peruse.
Also the difference, sir. Ultimately, if they are conducting the suitability test, then only you can be promoted.
My lord, may kindly peruse page 45, my lord.
45, yeah.
I had submitted an application, my lord.
28/1.
2019, my lord. And I was furnished with the information on the RTI Act at page 75 in the year 2021 that the posts were surrendered. But as to on which day the posts were surrendered, they are silent.
That is there, but
And-
ultimately, as per their stand taken in the, before the, this tribunal as well as the this suitability test, they used to conduct with how much interval?
Not more than 6 months, the gap has to be there.
Not more than 6 months, nah.
But in the case when there was specific direction to the respondents
This
at
is
para
that
5,
As per para 212 of IREM, the suitability should not be held at the interval, it should not be less than
less than 6 months.
less than 6 months. The last suitability test was conducted on 26/11/2018.
Yes, ma'am. But they are silent about the fact that when there was specific order by order dated 7/8/2023, their affidavit is silent about Babul Kanti Day and the other person, my lord.
What?
About as regards after he was after Babul Kanti Day retired, whether the case of the petitioner could have been considered for promotion.
Sir, until and unless you pass the suitability test, how can they be considered that, sir?
So that is the reason why they are silent about it, my lord.
Sir, first of all, on 26/11/2000, this
18.
this suitability test was conducted.
Yes, my lord.
You have not appeared or even not cleared that suitability test.
Yes, my lord.
The next suitability test was supposed to conduct, after May or something,
Yes, my lord.
April or May of 19.
May 2019.
Yes, my
Prior
lord.
to that, you have been retired, sir. How can your case even be considered, sir?
And my lord, in paragraph 14, my lord, I had in my writ petition, I have read my there's one regulation, my lord, regulation of the railways, my lord. 214, my lord. This is rules governing promotion of subordinate staff, my lord. 214 says, my lord, non-selection posts will be filled up by promotion of senior most suitable railway suitability servant suitability, whether an individual or group of railway servants being determined by the authority competent to fill the post on the basis of record of service and or departmental test if necessary. A senior railway servant may be passed over only if he or she has been declared unfit for holding the post in question, my lord. So as regard that, my lord, in my paragraph 14 of my petition, my lord, I have made a categorical assertion to that regard, my lord, that I was not provided an opportunity, and there is no denial to that effect, my lord.
By this rule 214, the person, which person junior 2 was promoted?
Prior to me, my lord, Deepak Kumar Chakraborty, he was ex senior technician FPO, my lord. He was promoted. He is senior to me, my lord, at page.
So he's senior to you.
Thereafter, I should have been considered, my lord, that they didn't
But
consider.
that's the whole thing is that yes, you should have been considered, but subject to the passing of suitability test. That has not been conducted.
And as per 214, if I'm being declared unfit, they didn't declare me unfit, my lord.
It is a question of declaring you fit or unfit. When you have not passed the suitability test, how can the court can, the relief can be granted to you? And admittedly, that can't be conducted before,
6 months
in
time.
less than 6 months from the last test conducted.
That is clear. They have not denied that paragraph, my lord. Paragraph 14, they have not denied. The assertion which I have made in my repetition, my lord. As regards that, I was passed over, no opportunity was granted to the
passed
petition.
over,
I was not considered for the suitability test.
and your junior was considered.
That assertion I have not made, but I was not considered for the suitability test.
But then if ultimately the discrimination, if the person less meritorious or junior to you was considered, then only the cause of action arose to you. This issue is filed by being able with the order dated 12th of January 2021, passed by the Central Administrative Tribunal, Guwahati. Hereinafter to be referred as tribunal in original application number 12 or 21, whereby learned whereby the learned tribunal has rejected the dismissed OA filed on behalf of the appellant, being agreed with the action of the by the petitioner being agreed with the action of the respondents of not of denying promotion to the post of senior tech slash FTO in the railway, railways, full stop. The learned tribunal has taken into consideration the fact that for the purpose of promotion on the post of senior technician slash FPO in the railways, a person is required to pass the suitability test. However, the Indian Railway Establishment Manual IREM provides that the suitability check should be held at the interval which should not be less than 6 months, and the last suitability test was conducted on 26/11/2018. And before expiry of the 6 months period, the petitioner retired in February
February 2019.
2019. And as such, when the petitioner has not passed the suitability test, there is no question of promoting the petitioner on the post of senior technician FPU. Full stop. The tribunal has also not also taken into consideration the letter written by the DRM not Frontier Railway dated 26/3/2019. Here, response of the DRA so and so, wherein the stand of the railway is that as on 1/4/2018. Sent to the petitioner, sent to the counsel for the petitioner, counsel for the petitioner in response to the notice sent, sent on behalf of the petitioner, and has come to the conclusion that the respondent authorities have not made any unjust treatment on the applicant as evident from the said letter. Having heard the learned counsel for the party, we don't find any case for indifference in the order to pass or the family, hence the petition dismissed.
Item 15.
Lordship, I beg to appear for the petitioner in the matter.
Sir, why are you appearing through VC?
Lordship actually was a little unwell because of the pollution here.
Take rest. Today also, we have also done much labor, so take rest any other date.
May I request for 5th of December, Your Lordship?
5th of December, okay done. 5th of December.
Deeply obliged, deeply
Take
obliged.
care.
Obliged, Your Lordship.
5th is the hearing day,
6th is Friday.
Friday. Nah, then any other date, hearing day,
On 12th.
12th.
Obliged.
12th. Okay.